May I have kindly to
Inclusion, hand over the slip.
content matter. It was relaxation of condition. The order passed for your lordships. Relaxation of
Assigned matter formula inclusion.
You assign matter.
Lord, it was an old data assigned matter. Your lordship had passed interim orders, Lord.
Please
order
release
for
it, Mr. Kormakar. We'll be, hey, assign matter fatter যেগুলো দিও লিস্টে to be mentioned এনো কাল পরশু কথা বলে নিও. May not be possible, Mr.
But
Kormakar.
my lord has heard substantive. Lord.
Let it be listed. Let us we'll see. Yes, bail. Bail. To be mentioned tomorrow.
Appellate side item number 1.
For correction. Yes, lordship. Please. Here. He defected to Kenya. Name change, right? No.
Yes, what the correction?
I don't know, lordship, who mentioned it. I was my defect complaint of the in
It,
this matter, lord.
it is listed for correction.
It is it.
But it is for change of name.
Which name?
Which name?
We were under the impression that the petitioner has mentioned.
No, lordship. He has not mentioned. Who mentioned it? And it is a disposed matter, lordship.
হ্যাঁ সেটা উনি বলছেন প্রাচীর হয়ে ওনাকে দেখি সেখানে কোনো নামই নেই না না পাস ওভার কি আউট অফ লিস্ট নেই তো হ্যাঁ আউট অফ লিস্ট
He mentioned this.
ইউ অ্যাপিয়ার ফর হুম
I am for the defect complaint, lordship. I was defect complaint.
ইউ আর দ্য স্টেট
Also, I have talked with the petitioner, lordship.
ভেরি ওয়েল
He also did not mention.
Item number 2.
ইয়েস
There is a typing mistake in the order of the
টেল আস হোয়াট দ্য মিস্টেক ইট ইজ উইল কারেক্ট ইট
sections. In place of 302B, it would be 304B, and in place of 302, it would be 306. Section
30
6.
এই লিখে নাও 304B হবে এটার জায়গায় 302B এর জায়গায় 304B আর 302 এর জায়গায় 306 হবে let the order dated let the cause title of the order dated June 14, 2024 be corrected by substituting sections 304 capital B and 306 in the place and stead of section 302 capital B and section 302 respectively. Correct?
Yes, my lord.
Stop. Let this order be incorporated. Let this correction be incorporated in the order dated such and such.
Item number 3.
My lord, in this matter also, in place of section 302B, it would be 304B, and in place, yes, the same.
Item number 4.
Great.
I am for the petition, madam. My lord, the second page of the order, my lord, releasing court is, my lord, the Katwa Purbo Bardhaman, ACGM Katwa Purbo Bardhaman. Here it is, ACGM Lalbagh Murshidabad. It's wrongly written. What should be? Katwa Purbo Bardhaman, madam. Katwa Purbo Bardhaman.
Read the first paragraph of the second page
Sixth
of
line
the
and seventh line.
order dated June 20, 2024 be corrected by substituting কাঠুয়া কমা পূর্ব বর্ধমান, এটাকে কাঠুয়া কমা পূর্ব বর্ধমানটা ইনভার্ট কমা ইন দ্য প্লেস অ্যান্ড স্টেড অফ, আবার কোট করো, লালবাগ at মুর্শিদাবাদ, স্টপ আনকোট। Let this correction be incorporated in the order dated such and such.
My lord, kindly ACGM Katwa Purbo Bardhaman, kindly.
ACGM is already there.
আরে এটা লালবাগ মুর্শিদাবাদ।
Item number 5, for the petition. This is a case where there is no recovery from the petitioner. On last occasion, the lordship directed the state to take.
What is the status of the trial?
Sheet submitted.
How long you are in custody?
66.
66 days. Charge sheet has been filed. Commercial quantity of what?
Pencil. The principal accused is on bail, my lord.
এই কি দিয়েছো?
376 to the 448, 376 to
না না না,
This Delhi police station case number 35.
NDPS 919.
ভুল এটা
অর্ডারটা ভুল ফাইলে লাগিয়েছে।
হ্যাঁ এটা দেখো 448
হ্যাঁ, তো কিছু একটা গোলমাল আছে, এই সেকশন গুলো তো হবে না। আর এই অর্ডারটা আমার ফাইলে নেই কেন?
লাস্ট অর্ডার পাস না
হ্যাঁ, ডিবি বার করে লাগিয়েছে।
yes
Yes.
65. 66.
So why should we grant you bail?
And no seizure from the petitioner only on the basis of statement of co-accused. This petitioner was implicated, which is inadmissible evidence.
Yes, what do you say? What is against him? Nothing was seized, he is saying. Co-accused statement. Is that admissible? What is your case? He ran away from the spot, or what is it?
Statement of the person, the supplier.
so conviction
All
How many
those cases
convictions
he
are
was
there?
on anticipatory bail granted by this honorable court. All those cases, there was no seizure from the petitioner. All those cases on the basis of statement of court. Of those orders.
Normally, if you are the supplier, there will be no seizure. Is the person to whom you have supplied?
If I am the supplier, I must have a go down. There must be a seizure because I was in custody for almost 66 days. There must be some incriminating material.
ভুল করতে পারছি না, state ঠিক আছে। What about other accused persons? Is there any absconding accused? No.
I have instructed
So investigation is complete then.
principal accused is on bail.
Principal accused on-
Yes.
Principal accused by from whom the seizure was made?
Statutory.
Oh, statutory bail. Issue. The petitioner says that no contraband item was seized from him. Stop. He has been implicated on the basis of statement of co-accused. Stop. The principal accused has been granted statutory bail. Stop.
Whether this accused was taken into police custody? PC নিয়েছিল? Why PC was not taken? Police custody was not taken?
Stop. The petitioner was never taken into police custody. Stop.
No, my lord, PC was taken. It was from the order dated 23.
What can I do?
কেটে দাও এই লাস্টটা।
No.
This one PC.
Was taken, anything was recovered from PC?
No.
Nothing. Was taken into police custody, but nothing was recovered from him. Stop. He is in custody for 66 days. Stop. Investigation is complete. Stop. Charge sheet has been filed. Stop. He prays for bail. Paragraph. We find from the material on record that prima facie there is no sufficient material to implicate the petitioner. Stop. Accepting the statement of the co-accused. Stop. There is nothing. Stop. Hence, paragraph, we are of the opinion that the petitioner has been able to overcome the restriction in section 37 of the NDPS Act. Paragraph accordingly.
When you have got the CD? When you have got the CD? Yesterday? When? So you have not studied. Next.
Item number 6.
Well, time for the petitioner.
Yes. What was recovered?
Petitioner. My lord, 5.1 liter of codeine mixture was recovered from joint possession of one Alauddin Ghazi Mondal and me. My lord, I am in custody for 2 years, 4 months.
Alauddin has been granted bail.
Granted bail from this honorable court.
Same, parity. Issue. Commercial quantity of codeine mixture was recovered from the joint possession of this petitioner and a co-accused person. Stop. That person has been granted bail by this court. You have the order.
Yes. Page 20.
By this court by order dated
26/4/2024.
April 26, 2024, passed by a coordinate bench in CRM NDPS number 721 of 2024. Stop. Paragraph accordingly on the ground of parity, as also keeping in view that the petitioner is in custody for 2 years and 4 months, and there is no appreciable progress in the trial, we are inclined to enlarge the petitioner on bail. Paragraph accordingly.
Much obliged.
Item number 7.
My lord, may I please your lordship? My lord, petitioner 3 years, 9 months in custody, my lord. Petitioner was arrested on 25/9/2020. Charge sheet submitted. Charges framed on 5th April 2022. Out of 7 witnesses, 2 witnesses examined. This when I moved this bail application before this honorable court on 17/11/2003.
Yes, what is the status? Tell us.
Out of 6 only
Two.
examined.
Two.
One is custody last 3 years, 9 months. There is admitted.
See,
Earlier progress in rejected. So there is no progress. Admitted.
Last rejected when?
Last rejected on my lord. 17th of November 2020.
17 November, my lord.
Page 13.
With a direction to conclude the trial as early as possible, my lord. Since then, no progress, my lord.
Last witness examined on 5/8/2023.
Yes, 5/8/2020, my lord. No witness.
The report was also
Submitted.
Issue.
আসতে হবে।
No, she too, obviously. The petitioner renews his prayer for bail, which was earlier rejected twice,
Yes, sir.
lastly on November 17, 2023 in CRM, lastly by order dated November 17, 2023, passed in CRM NDPS 1746 of 2023. Stop. By that order, a coordinate bench had directed the trial court to expedite the trial and conclude the same at an early date. Paragraph. The petitioner says that that order has not been followed in its true intent and spirit. Stop. He is in custody for 3 years and 9 months. Stop. Only 2 out of 6 witnesses have been examined till date. Stop. The last examination of witness was on August 5, 2023. Stop. He prays for bail. Paragraph. Learned advocate for the state files a report which we keep on record. Stop. We find no acceptable explanation for the delay in progress of trial. Paragraph. The fundamental right of a citizen to personal liberty under Article 21 cannot be lost sight of. Stop. In the present case, there has been inordinate delay in the progress of trial, and therefore the restrictions in Section 37 of the NDPS Act stand overridden. Stop. We are inclined to grant bail to the petitioner solely on the ground of delay in the progress of trial. Paragraph accordingly.
Satisfaction of the chief judicial.
They cannot satisfaction.
The chief judicial magistrate. Bhasan.
Item number 8.
My lord, I am for the petitioner. My lord, I am renewing my prayer for bail. Presently, I am in custody for 2 years and 6 months, my lord. My lord, I am renewing on the ground of a change in circumstances, my lord. My lord, co-accused person who is standing on similar footing has been granted bail by the Honorable Apex Court, my lord. I have annexed the order, my lord. Starting from page 8. My lord, no direct recovery from my possession. It is alleged that I was taken into police custody prior to initiation of a case. Later, I have stated something before the police, and pursuant to that statement, my lord, police intercepted a truck, and from the truck, my lord, police find three persons, and from the truck, police.
Yes, sir.
I'm in custody for 2 years, 6 months presently.
What is the status of the trial?
Last witness, can you see the order, last order? Only, on such date I was present. For defense counsel,
How is this accused standing on a different footing from
difference between my lord.
Shubhankar?
It's released on bail.
Yes.
Last week.
যদি সেম ফুটিং হয়ে তোমায় দিতে হবে, সুপ্রিম কোর্ট বেল দিয়েছে।
He has taken adjournment. Have you gone to Calcutta?
My lord,
Antecedent of this petitioner, several cases pending against him. Not only that, from the position of the petitioner, one mobile phone has been seized. And from the same mobile phone, driver, track number and driver number was sent from the Manipur. That was seized. Not only that, my lord, well, see that, my lord.
So show us the Caesar list.
Last witness.
Last
my lord, my instruction is out of 23, my lord, 12 have been examined.
no, last witness he is saying we'll record that and we'll say 2 months. 2 months, no 1 month. Sir, you are not ready in the matter. Caesar list বলছে এই লোকটার নাম হচ্ছে কি নাম? বালা, হরে কৃষ্ণ বালা। এই
Yes. Tell me, from whom sees Sheikh Samad Hussain, Sheikh Asif, son of Sheikh Alauddin. They are the witnesses.
My lord, seized from
Yes.
my lord, seized from a truck. My lord, in the truck, my lord, 3 persons are there. That is Khambi Singh, that is one Ning Thukong, and another one is the Khalashi, my lord. My lord, while
Your name is there in the Caesar.
my lord, the name of the Shubhankar Vala is also there in the Caesar list, my lord.
What we are saying, you are sure. Yes, all right, but Shubhankar had no antecedent.
My lord, regarding the antecedent, my lord, all these cases are, my lord, no recovery, my lord, and in as
No,
many
sir,
as
no, sir.
3.
Last witness is being examined.
Well, kindly record that they are saying that last witness has been.
Last week, can you see the out of 23, only 12 witnesses have been examined.
That is my instruction.
You are saying that this is the last witness. Only I, investigation officer. So after that, you will conclude your evidence. Yes, my lord.
Esho.
Kindly record, my lord.
Yes. This is the third application for bail.
My lord,
filed
second
by the-
application.
Second application, you say.
Yes. Second application for bail filed by the petitioner. Stop. His first application was dismissed by a coordinate bench by an order dated July 20, 2023, passed in CRM NDPS number 1284 of 2023. Stop. The petitioner renews his prayer on the ground that subsequent to the aforesaid rejection of his prayer, the Honorable Supreme Court has been pleased to grant bail to a co-accused person by an order dated May 15, 2024, passed in May 20, 2024. Stop. The petitioner says that he stands on the same footing as the aforesaid person. Paragraph. Learned advocate for the state opposes the prayer and says that the other person who was granted bail did not have antecedents as recorded by the Honorable Supreme Court. Stop. This person has antecedents. Stop. Several NDPS cases are pending against him. Stop. The last witness is being examined by the prosecution. Stop. The trial is on the verge of conclusion. Paragraph. Considering the facts and circumstances of the case and that 824 kgs of ganja was seized from the accused persons, and that the trial is about to conclude, we are not inclined to grant bail to the petitioner. Stop. He does not stand on the same footing as the accused person who has been granted bail by the Honorable Supreme Court. Paragraph. The prayer for bail is rejected. Paragraph. However, since the petitioner is in custody for
2 years, 6 months.
2 years, 6 months, we direct the learned trial court to conclude the trial by delivering judgment within 2 months from the next date fixed for recording of evidence.
Deeply obliged.
We are not concerned, sir.
Deeply obliged.
We are not concerned.
Item number 9.
Paragraph. If the trial is not concluded within the time period indicated herein, the petitioner will be entitled to renew his prayer for bail.
I'm deeply.
Item number 9.
My Lordship, I am here for the petitioner. Petitioner is in the custody for 3 years, 8 months, my Lordship.
Petitioner,
Last occasion also petitioner
And there was a...
come.
No, I am here for the petitioner, my Lordship.
Pass over what
Lordship,
to
I
do.
am
Second call will never
My
happen.
Lordship, I am here for the petitioner, my Lordship. My Lordship, I am here for the petitioner.
Lekho.
My
On
Lordship,
the
I am
last
here for the
occasion also
petitioner.
when the matter was called on, the petitioner.
My Lordship, I am
was
here
not
for the
represented.
petitioner.
Stop. He is not represented today.
My Lordship, I am
Are you
here for
also
the
taken up?
petitioner.
On the last occasion when the matter was called, the petitioner was not represented. Stop.
My Lordship, I am here for the petitioner. My Lordship, I am here for the petitioner, my Lordship.
Carry on, Kiridao.
Yeah, my Lordship, in this matter, accused in the petitioner is in the custody for 3 years, 8 months, my Lordship. There was no recovery at all, basically, because the petitioner was in the custody in the another matter. And there is no name in the FIR, my Lordship. They have only added up his name. And another matter, in the coordinating bench, the petitioner has already been granted the bail. And therefore, my Lordship, I renewed my prayer for the bail because there is no recovery in this matter from this case.
Petitioner has been granted bail.
Yeah, in the another matter, my Lordship, let me clarify you, my Lordship. When this matter, in this matter, petitioner name has been taken after the 6 months of the FIR. That time, the petitioner was in the custody in the another matter. Therefore, there is no recovery at all, my Lordship. In this matter, there is no recovery. And this is only on the false disclosure statement, my Lordship. They have included his name in the charge sheet. But there is no recovery at all. Now, in another matter, because it's a 3 year, 8 month, the petitioner still got the bail in the another matter, but languishing in the custody due to this matter. And therefore, my Lordship, I am praying for my bail.
Very well. Yes, state.
Lordship, kindly come to page 8. Petitioner's last rejection on 16th of January 2024. There, this Honorable Court directed the trial to be completed within 1 year. At
Ye-
page
Yes, my Lordship, last 5 months, no progress in the trial. In 3.5 years, only complainant had been examined so far, my Lordship. No
Out-
progress in the trial.
out of that means
Out of 13.
When was the last examination?
Last examination, Lordship, in June, the date was fixed, but the learned presiding officer was on leave. Next date is on
So effectively, when was the last examination?
May
May.
2024.
May.
After direction
this
of this
order.
honorable court,
Sorry, sir. You come back after once this 1 year period elapses. You can.
No, my lordship, let me come to that, my lordship. Sector 37 provision, my lordship. When there is no recovery in this particular case, my lordship, and there is 6 months, there is no progress in the trial. My lordship, the last time, end of the day, this is a completion of the case. But the question arises here, there is no progress in the trial. So I am complying with the two rules, which exactly, number one, because Honorable Supreme Court has clearly said that, my lordship, means 3 year, 8 months, my lordship, I am already in the custody. And last 4 months, even after the bail also, I am in the custody. Due to this case. And there is no role of mine, my lordship, in this case.
Why you have not moved order Supreme Court against the order dated 16/1/2024? Why you have
My lordship, let me put the fact together, my lordship, because I got the bail in the month of March, my lordship, from my next case, because end of the day, there were 2 cases. Now that another case, I've already got the bail, my lordship. But after bail also, I'm in the custody due to this case. And in this case, there is no recovery. No recovery, my lordship. That is there. And 3 year, 8 months have passed. 3 year, 8 have passed, and only 1 witness has been examined. This is the pace of the trial.
This submission was recorded by in earlier order, and your submission was considered and rejected.
My lordship, here I would like to put the context, my lordship. Please get the report of last 6 months, what they have done in the trial. My lordship, they have clearly, the PP is clearly saying that last date nothing happened. Public prosecutor was on leave. This is the conduct of the basically the trial court.
File a report about the progress after this order of rejection.
Yes, my lordship. That's
the state shall file a report on the next date as regards the progress that has been made in the trial after a coordinate bench passed the order dated January 16, 2024 in CRM NDPS 37 of 2024, rejecting the petitioner's earlier bail application. Paragraph lists this matter once again next Tuesday. Next Tuesday did the other.
great. Oblige, my lordship. Oblige.
Item number 10.
10, my lord, I am for the petitioner.
That's for this two.
My lord, I am for the petitioner. 161 bottles of Fencidril from one Gina room. My lord, from me, nothing has been recovered. The only evidence against me is that co-accused statement who says that I have fled away. Standard form of allegation, if I may be permitted to
It's
say.
an organized crime, sir.
My lord,
Why
nothing has been
would
recovered.
certainly the accused say that you fled from the spot?
But-
There are 130 crore people in India.
Still,
Suddenly, why only you? He will say fled from that place.
but
What
still,
is this?
But he fled away, but the motorcycle speaks that the motorcycle is on his name.
Motorcycle is registered.
Leaving the
in Nepal.
motorcycle, you say.
Yes.
but this is quite surprising for me.
Why you have
What do you want to do?
if you use the motorcycle motorbike, you could have
Well, this is surprising. This fact was not known to me.
And the
But
Malad
this is
kindly
from
see
RTO.
the rejection from the Malad the coordinate bench.
But
What is
this
your
is
name?
from RTO.
showing. No problem. Yes. OC, Raninagar PS.
No, but
No,
this
that's
is
why-
from
that-
RTO.
লিখতে শুরু
And Malad kindly see the rejection of the coordinate bench, Malad, the anticipatory bail rejection.
You did not go through
Yes,
the,
yes, yes.
the order of rejection.
No, anticipatory.
Anticipated.
Anticipatory will not stand in the way.
And Malad
Malad-
kindly see the seizure list, Malad number.
Your anticipatory bail was rejected
Anticipatory, man.
on the ground that the motorcycle.
But now I am in custody.
issue.
For this, but
The petitioner says that there was no recovery of contraband item from him. Stop. He has been implicated solely on the basis of statement made by a co-accused that he allegedly fled away from the place of seizure. Stop. Paragraph, learned advocate for the petitioner, for the state produces the case diary and draws our attention to the fact that the motorcycle from which seizure of commercial quantity of, what is it, gaja? No, what is it?
No, consider it.
Consider it.
161 bottles of
Was
consider.
made, is registered in the name of the petitioner. Paragraph, we also find that a coordinate bench rejected the petitioner's prayer for anticipatory bail by an order dated February 6, 2024, passed in CRM bracket A 5466 of 2023 on the ground of seizure of commercial quantity of contraband from a motorcycle registered in the name of the petitioner. Paragraph, in view of the aforesaid, we are not inclined.
Only one favor I'll ask, that is, chemical report is yet to come. Kindly direct that it should be done within 1 month or something like that.
Stop.
That is
Trial.
Paragraph,
Chemical report,
we are
otherwise
told that the petitioner is in custody for
122.
122 days. Stop. Chemical report is awaited. Stop. These state shall, the state shall ensure.
Yes.
But
Who shall ensure?
Director FSL, my lord. Otherwise,
The director, FSL, shall ensure that the chemical report is placed before the learned trial court within a month from the date of communication of this order by the parties to the director, FSL.
Item number 11.
I am for the petitioners.
এই dismiss বলেছো তো?
3 years, 6 months in custody, Lordship. 5 out of 8 witnesses examined in full. PW6 in part, Lordship.
how much time? How much?
50 bottles of fentanyl, Lordship.
6 in part.
6 in part.
What do you mean 6 in part? Number 6 in part.
Yes. Number 6 in part. So 5 has been completed. 6th is the in part. Next date is on.
What is the material against him?
From them, 25 bottles each of fentanyl was recovered.
Any earlier rejection?
No,
No,
Lordship.
my
First
lord,
application. 3 years, 6 months in custody, Lordship.
How many years? 3 years.
3 years, 6 months.
2 মাস করে ছেড়ে দাও তো আগে।
How many witnesses are to be examined?
Total 7, 6, 5 has
As
been
per
examined in
supplement-
full. 6th has been examined in part. 28 is the
We'll-
Incriminating materials are there.
my lord.
Lordship, as
been
per
identified.
supplementary,
My lord.
as
We'll
per
record
supplementary
that.
charge
You
sheet,
have-
8 witnesses.
Have to conclude within 2 months. Otherwise, he can come back.
Supplementary
Issue.
charge sheet.
26th is the next, 28th is the next date.
8 witnesses, he is saying.
As per supplementary charge sheet.
Supplementary evidence.
From the IO, I have based on.
Commercial quantity of
He has given
fentanyl
7 witnesses.
syrup
One of the first
was seized from the joint possession of the petitioners. Stop. They say that they are in custody for 3 years, 6 months. Stop. They should be immediately enlarged on bail. Paragraph.
But he has stated that.
Learned advocate for the state points out that 5 out of 7 witnesses have been examined in full. Stop.
As per report of the IO.
In full, as per the report of the investigating officer. Stop. The 6th witness has been examined in part.
28 is the next.
Stop.
28 June.
Yes, ma'am.
June 28, 2024, has been fixed as the date for further examination of witness. Paragraph. In view of the prima facie incriminating material against the petitioners and also keeping in mind that the trial is on the verge of conclusion, we are not inclined to entertain this application for bail, entertain the prayer for bail. Prayer for bail, stop. Paragraph, CRM is dismissed. Paragraph, however, keeping in mind that the petitioners have been in incarceration for a long period of time, the learned trial court is directed to conclude the trial by delivery of judgment within 2 months from the next date fixed for recording of evidence. Stop. If the trial is not so concluded, comma, the petitioner will be entitled to renew his prayer for bail. Petitioners renew their prayer for bail.
Grateful, Your Lord.
Item number 12.
I'm for the petition.
Done for this.
Well, kindly see page 6. That is my last rejection on 18th May 2023. May 2023.
How many rejections? One only.
On only 522 bottles of fentanyl. Well, admittedly, there is no recovery. That is admitted in the last order. But my prayer was renewed because
Sir,
of the delay in trial.
Twice.
Twice. CRMA. One anticipatory.
Oh, one anticipatory bail, yes.
Driver of the vehicle, why that there was no recovery because he was driving a bus in which several old people and children were also traveling. So when the bus was intercepted, the conductor was arrested from the spot, but the driver was not arrested at that point of time because the bus was full and the passengers had to be taken to the destination. But later on, there were several attempts made to arrest him. He kept absconding despite rejection of anticipation.
So anybody can keep the bag in the passenger bus? Yes, Mallory. This is a public bus.
Conductor was arrested from the spot. 18
How many years he has been in custody? Mallory, 1 year and 7 months I am in custody, Mallory.
Status
Out
of
of
trial.
7. No, Mallory. Out of 17, no, Mallory. Last 3 dates, no witness.
Out of 17, not one examined.
No.
charge was framed from 12th of October 2023. Thereafter, only one schedule of witness was there, in which nothing took
3 dates, no witness has come to depose, Mallory.
August is the next date for
1 year. 1 year.
one-
1 year. 1
1
year.
year, 7 months.
1 year complete.
Mallory, no time direction, Mallory.
Not necessary.
Yes.
We are not allowing this because on merit you have suffered a rejection.
So you can withdraw. No, Mallory.
We'll Esho. The petitioner renews his prayer for bail, which was rejected earlier by a coordinate bench by an order dated May 18, 2023, passed in CRM NDPS 1019 of 2023. Paragraph. The petitioner says that he is in custody for 1 year and 7 months. Stop. Out of 17 witnesses named in the charge sheet, comma, not even one witness has been examined. Stop. He prays for bail. Stop. Prays for bail. Paragraph. Learned advocate for the state says that charge was framed in October 2023. Stop. Thereafter, one schedule for examination of witness was fixed, but no witness could be examined on the fixed dates. Stop. The next date for examination is August 16, 2024. Stop. Paragraph. We find from the material on record that prima facie we find from the case diary that prima facie there are incriminating material against the petitioner. One person has come.
Yes, Mallory.
Petitioner. Stop. Commercial quantity of fencidril syrup was seized from a bus, of which the petitioner was the driver.
Driver of the state.
Stop. In view of in view of the restriction in section 37 of the NDPS Act, comma, we are not inclined to grant bail to the petitioner. Paragraph, however, comma, since the petitioner has been in custody for an appreciable length of time, comma, the learned trial court is directed to expedite the trial to the utmost and conclude the same as soon as possible, but definitely within 1 year from the next date fixed for recording of evidence. Paragraph. Dismissed. Dismissed आगे बोलबे तारपरे trial court. Next, we make it clear that if the trial is not concluded within the time period indicated above, oh, you said you don't want a time period, huh? Huh?
As your lordship, my lord.
But you said you don't.
I said no, but
But then we just simply reject.
yes, ma'am.
তাহলে এ করে দাও, reject করে দাও।
As early as possible.
As early as possible বলে
As
দাও।
early.
খালি শুধু as early as possible.
I'm declared. Item number 13.
No, I'm for the petitioner, my lord. Now, this is a case under section 8C, 21C and 25, 29 of the NDPS Act. On the basis of a source information, a raid was conducted in the house of one Shima Costa. A huge quantity of codeine mixture was found from her house, and thereafter it came to know that petition number 1, Amorish Kumar Das, was running a business of codeine mixture, and he stored in the house of Shima Costa. Your lordship, kindly see
Without her knowledge.
my lord.
Without her knowledge.
No.
With her knowledge.
No, Shima Costa is also knowing fully well. I am pressing in respect to the petition number 2. The person was engaged as a laborer for packaging the fentanyl bottles in cartons. The person from his possession, nothing was recovered. The person was a mere laborer. My humble submission is this: in respect of the petition number 2, I am there's allegation against petition number 1. He is running that business and he stored the articles in the house of Shima Costa. That was recovered. And moreover,
How is the petitioner number 1 and Shima related? Why would suddenly in Shima's house the petitioner store fancy?
they are running the business for a long time.
Together. They are running the business.
Business, petition number 1. And moreover, on the person to the statement made by the petitioner number 1, from his father's house also, some articles were recovered.
Shima is a co-accused.
Co-accused
In custody.
is in custody.
You are not pressing the
Petition number 1, but petition,
you are not plus please. You are not pressing the prayer for petitioner number 1.
1.
Not
The allegation
Number
is
2,
there.
what
But
do
in
you have?
respect to the, your lordship, kindly consider in respect to petition number 2.
They were involved in this, and for the acquired mallet, and from there mallet, 16 cardboard, 16 into 20 plus mallet, 194 bottles pencil was recovered. Subsequently from Amorish mallet, 7 cardboard was.
Omorish is not pressing. Please tell us about Mutahar.
So, acquired mallet, all of them are engaged in this mallet business mallet. Can you see the mallet?
antecedent of Utharan
Mutahar mallet.
is the labor.
No, mallet is not. Mallet is the FIR, his labor. It is his mallet to the submission and his labor. But from the CD mallet, it is not clear whether he is labor or something else. Mallet. 6 persons were there. Mallet present mallet.
Yes.
And all are
Caesar list mentions Mutahar.
name is there.
In the serial list, your lordship,
No, huge
yeah,
quantity.
because he was engaged as a laborer. But my submission is from my possession, it was not recovered. From the possession of Amorish Kumar.
One,
Please allow,
sir,
my lord.
we also have a right to speak. Madam, who is Shadab Khan? Another co-accused. Co-accused. His prayer was rejected.
Sadab Khan.
His prayer was rejected. Are you aware of that? Same footing. Shadab Khan. Isho. The petitioners, how long in custody?
9 months. Only
Okay.
charge sheet submitted.
Say that they are in custody for 9 months. Stop. Charge sheet has been submitted. Stop. There is no need to detain them any further. Now, age karo. Learned advocate for the petitioners says that he, on instruction, is not pressing the application for bail insofar as the petitioner number 1 is concerned.
Naam diye, Amorish
I.e. Amorish
Das.
Kumar Das. Stop. Accordingly, the bail application stands dismissed for non-prosecution insofar as
Bail prayer of petitioner number. Bail
Huh?
prayer application.
the bail. Bail application কি বলেছে?
Joint application. Bill application.
আচ্ছা, bail prayer of the petitioner
So
number
see,
one
there is direct allegation against him for that.
Uh,
like,
stands stands rejected. Stands rejected. Yeah, rejected. Stop. হ্যাঁ, সে তো বলেই দিয়েছি আগে। অ্যাকর্ডিংলি থেকে দরকার নেই। হ্যাঁ, কি হলো, কি গন্ডগোল হচ্ছে?
Accordingly, his bail prayer is
গোড়া থেকে পড়ো। হ্যাঁ, no, accordingly, the bail petition is rejected insofar as the petitioner number, no problem, is rejected or is dismissed as not pressed insofar as the petitioner number one is concerned. Paragraph. Insofar as the petitioner number two is concerned, comma, it is submitted that he is in custody for 9 months. Stop. Charge sheet has been submitted. Stop. There is no need to detain him any further. Stop. Paragraph. Learned advocate for the state opposes the prayer for bail. Stop. She points out from the Caesar list that 6 persons were present at the place from where huge quantity of fencidril was recovered, was seized. Stop. Such
794 bottles.
huge quantity bracketed in the 4794 bottles. Right, close of fencidril was seized. Stop. The petitioner was this petitioner was also present at that spot. Stop. Although this petitioner is claiming to be a mere laborer, comma, there is nothing in the case diary to indicate so. Paragraph. Having considered the material on record and material record which indicates prima facie involvement of this petitioner in the alleged crime, and in view of the restriction in section 37 of the NDPS Act, we are not inclined to allow this application insofar as the petitioner number two is concerned. Stop. We also notice that a co-accused who appears to be standing on the same footing as this petitioner, had applied for bail. Stop. Such prayer was rejected by a coordinate bench by an order dated February 23, 2024, passed in CRM NDPS 361 of 2024. Paragraph accordingly dismissed.
Item number 14.
My lord, I am for the petitioner. My lord, the petitioner is in custody for for 2 years and 12 days. My lord, charges were framed on 17th of July 2023, but till date, not a single witness had been examined. My lord, co-accused prayer for bail was rejected when they were not in custody for 2 years. That was in April, because my lord, they were in too much short of 2 years that time. Now, my lord knows this, my lord, the present proposition of law subject to lordship's correction, my lord, starting from Robi Kapoor to my lord, these honorable court's view, that when a petitioner is in custody for 2 years with no witness examined, my lord, the Article 21 is violated. And my lord,
yes.
My lord, I have the judgments also along with me.
Delay is concerned, lordship. PO only, bar resolution.
9 dates.
3 dates, no witness was present.
Problem is the Supreme Court doesn't make any distinction between causes of delay.
My lord, I have the judgments.
What was recovered?
My lord, 441 bottles of fencidril.
441.
441 bottles of
You are the sole
antecedent.
No, my lord. My lord, so for this petition,
sole accused.
no, my lord. There are 4 others.
Rejection.
My lord, this petitioner first time.
First time.
And 7 dates from my lord for 17th July.
Number 1 and 2 are BSF personnel. So that is why someone.
Sir, to be honest, we don't want to, but we have to.
Charge was framed when?
17th July 2023, 1 year.
কি করবো এসব? The petitioner says that he is in custody for 2 years and 9 days. 9 days?
12 days.
12 days. Stop. Charge was framed on October?
On 17 July 2023.
July 17, 2023. Stop. Since then, not a single witness has been examined. Stop. There are how many?
My lord, 7 witnesses in total.
7 witnesses named in the charge sheet. Stop. In view of the pronouncement of the Honorable Supreme Court in various decisions highlighting the importance of a citizen's fundamental right to personal liberty under Article 21 of the Constitution, the petitioner says that he should be immediately released on bail as there is no likelihood of early conclusion of the trial. Paragraph, learned advocate for the state points out that on various occasions, the trial had to be adjourned in view of the resolution of the bar and other reasons not attributable to the prosecution. Stop. However, he admits that none of the 7 witnesses has been examined till date. Paragraph, since there is no possibility of an early conclusion of the trial, keeping in mind the paramount importance of the right to personal liberty of a citizen, we are of the view that the restriction in Section 37 of the NDPS Act stands overridden, and the petitioner is entitled to bail solely on the ground of delay in progress of the trial. Paragraph accordingly.
I'm grateful, Your Lordships. Namta di de.
Item number 15.
May it please your lordship, I am for the petitioner. Lordship, I am renewing my prayer for bail. Allegation, I am in custody for 2 years, 3 months. Trial already started. My prayer was earlier rejected. Allegation is that 1,400 bottles of fentanyl was found.
What is the stage of the trial?
Lordship, out of 10 witnesses, 5 has already been examined. Lordship may kindly see the quality of their deposition. They hardly stated anything against me.
Next date has been fixed on 9 and 10 July. Out of 10, my lord, 5 witnesses have been already examined.
Sure.
Quality. We have to evaluate. Or there
Yes,
is no
Holmes.
incriminating materials.
1,400 bottles fentanyl recovered.
That is true. That is true.
Come back after 6 months. We are giving a 6 months period.
Lordship, 3 months, because they say that next date is July. I can also pray for let it be adjourned till July.
You can not press. You can not press. You can also not press.
No, if I not press it, if I not.
Very well. Issue. We'll adjourn it.
Yes, Lordship.
The petitioner says that he is in custody for
2 years, 3 months.
2 years and 3 months. Stop. The witnesses who have already been examined have stated nothing against him. Stop.
Against him, my lord, allegation is there, my lord.
Can we not record her submission?
We are recording her submission.
Stop. There is no possibility of an early conclusion of the trial. Stop. His personal liberty is being infringed. Stop. He should be granted bail immediately. Paragraph, learned advocate for the state draws our attention to the material on record. Stop. 1,400 bottles of fentanyl was allegedly recovered from the possession of this petitioner. Stop. Paragraph, we find that 5 out of 10 witnesses have been examined. Stop. The next date for examination is July. July 9, next dates, dates for examination are July 9 and 10, 2024. Stop. To paragraph, to see the progress in the trial, comma, at the suggestion of learned advocate for the petitioner, comma, we adjourn this matter till July 11, July 12, July 12. 12
Kindly make it after.
after
Please give me,
July 15. July 15. Stop on that date. The learned advocates for the parties shall apprise us of the exact status of the trial.
I'm highly obliged.
Item number 16.
My lord, I am for the petitioner, my lord. My lord, allegation under section 21C, 29, 22C, 29 of the NDPS Act, lordship. I am in custody for two years, 9 months, lordship. 2 years, 9 months, lordship. And
What is the stage of trial? Out of
10.
10.
Lordship,
Any-
kindly, lordship.
And 14th of August.
Lordship, kindly see, lordship. Several schedule has been fixed
When
and no
was-
witness was present, lordship. I have annexed
When
all
was
the
charge
orders.
framed?
Charge framed on 6/12/2022.
Charge was framed on 6/12/22, but your lordship, the witness started from 5th of October 22.
Why?
Lordship, 2 persons were absconding.
Oh, so, no, attributable. Accused persons. Separate দিতে আর করা যাবে না, জয়েন্ট পজিশনে সবসময় করছে আর সেপারেট করা যাবে।
Lordship, I have annexed.
Persons absconded.
Lordship, I have been arrested.
How many accused? 2 were absconding.
Lordship, kindly see the, I have annexed the order sheet, lordship. Kindly see the schedule. Lordship, page 23, lordship. 7/10/2023.
We are giving a time-bound program. If they don't do it, come back, we'll grant you bail. Issue. Commercial quantity of, there is no rejection earlier.
No.
Commercial quantity of contraband items was seized from the joint possession of 3 accused persons. Stop. Persons, comma, the petitioner being one of them.
Solely from him, the lordship, not from all 3 of them. One escaped and the bag was recovered from him.
Stop. There are 3 accused persons. Stop. Commercial quantity of contraband was recovered from the possession of this petitioner. Stop. He says that he is in custody for 2 years and 9 months. Stop. There is no possibility of an early conclusion of the trial. Stop. He should be enlarged on bail. Paragraph, learned advocate for the state says that there was some delay in the progress of the trial because the other 2 accused persons were absconding. Stop. Charge was finally framed in October 2022.
2.
Stop.
6/12/2022.
On December 6, 2022. Stop. Witness action started in October 5, 2023. Stop. 5 out of 10 witnesses have been examined. Stop.
Next date.
The next date of examination is August.
30th and 14th August.
Next dates করে দিও. Next schedule of examination is on 13 and 14 August, 2024. Stop. In view of the incriminating material available against the petitioner, his prayer for bail should not be granted. Paragraph. We are not inclined to allow the petitioner's prayer for bail immediately. Stop. There is sufficient prima facie incriminating material against him. Stop. However, paragraph D. However, since he is in custody for a long period of time, we direct the learned trial court to expedite the trial to the fullest and conclude the same by delivering judgment within 6 months from the next date fixed for recording of evidence.
Mm,
No.
Grateful, Lordship.
Item number 17.
Under 17, I am the petitioner. And I have made a prayer for bail on the ground of parity. Under this honorable bench as well as coordinate bench has granted bail to two co-accused persons. I stand on the same footing. My lord will find my order sheets I have annexed. My lord, with the petition. My lord, your lordship will.
Page
38 is the coordinate bench order. And my lord, this too by this honorable. Thereafter, your lordship has also granted.
Where is that?
I have handed over.
Oh, sure. Issue. The petitioner is one of 3 accused persons from whom there was recovery of alleged recovery of commercial quantity of contraband items. Stop. 2 other persons, the 2 co-accused persons have been granted bail by orders dated April 23, 2024, passed in CRM NDPS 685 of 2024 and dated June 12, 2024, passed in CRM NDPS 853 of 2024. Stop. Paragraph. We find that the petitioner stands on the same footing as the other 2 persons who have been enlarged on bail. Stop. Hence, he can claim parity. Paragraph accordingly. এটা কি 17 হলো?
Item number 18.
My lordship, I am here for the petitioner.
Yes.
My lordship, the petitioner is in the custody for more than 3 years, my lordship. And so far only one witness has been examined, my lordship. One very important thing, my lordship, before I go further, my lordship, I would like to, because the way the trial courts are operating, my lordship, in fact, in 2 years, 2.5 years, they don't even frame the charge, my lordship. This is what exactly the conduct. My lordship, Honorable Supreme Court in the recent judgment, even in the after 2 years, says that incarnation of delay is basically like a violation of fundamental rights and the violation of Article 21, my lordship. So, my lordship, what exactly is the conduct? Here you will see, I am praying for a bail on the ground of the delay. Secondary thing is that, my lordship, I am a driver by profession. I am a professional driver, my lordship. But the owner of the vehicle, my lordship, given the vehicle within 3 months, my lordship, he never made by the party. I have been falsely implicated in this case, my lordship. My whole family is suffering, my lordship. This is there. And I have nowhere to go, my lordship. This is there. So this is the situation altogether in my case, my lordship. And therefore, I would like to pray for my bail.
Lordship, will just see this petitioner had approached the Honorable Supreme Court
Yes.
with an application for bail. Honorable Apex Court had directed the trial to be completed within 2 years. This order was passed on 30th of October 2023.
Has he disclosed that in this petition?
No,
Sir, have you disclosed in this petition that you had approached the Supreme Court?
My lordship, I will say I acknowledge that, my lordship. I acknowledge that.
What do you
I
mean?
acknowledge that, my lordship.
Have you said in this petition?
My lordship, filed by my clerk there like a my lordship, but I am acknowledging in the court, my lordship, I take the responsibility on this. I am acknowledging. But my lordship, here, my lordship, I would like to say again. My lordship, what happened?
And basing on this order, my lord, the
My lordship,
Issue.
I am.
Sorry, sir. Suppression of material fact. Issue. The petitioner renews his prayer for bail. Stop. His prayer was earlier rejected by a coordinate bench by an order dated July 5,
2023.
2023, passed in CRM NDPS 1064 of 2023. This was carried to the Supreme Court.
Yes, that was correct.
Stop. Paragraph. From such rejection, the petitioner approached the Honorable Supreme Court. By filing a petition for special leave to appeal (CRL) criminal numbers 13716 of 2023. Stop. That special leave petition was disposed of by the Honorable Supreme Court by an order dated October 30, 2023, which is to the following effect. And I mean, the series October 30, 2023, merely by directing the trial court to conclude the trial within a period of 2 years, provided the petitioner extends all cooperation in the trial. Stop. It was further observed that if in the event the trial is not concluded within the aforesaid period, it will be open for the petitioner to revive his application for bail. Paragraph. The petitioner says that he is in custody for a long period of time. Hence,
3 years, 8 months, my lordship. More than 3 years, my lordship.
For more than 3 years, Karo. Stop. Hence, in view of his fundamental right to personal liberty under Article 21 of the Constitution, he should be immediately enlarged on bail. Paragraph. The petitioner has completely suppressed in the bail petition, the order of the Honorable Supreme Court referred to above. As per the said order, the trial court has been directed to conclude the trial 2 years, within 2 years from the date of that order. Stop. The period has not elapsed. Stop. Paragraph. Accordingly, we are not inclined to.
My lordship, one small legal discussion, my lordship. Give me 5 seconds, my lordship. My lordship, give me 5 seconds. I want to put something to the legal enlightenment of myself also, my lordship, because I'm also practicing in Supreme Court, my lordship.
Yes, we are very happy to hear that. But we have.
Yeah, my lordship, the conclusion of trial within a specific period given by the Honorable Supreme Court, my lordship, but at the same time, what progress has been made in the trial after that order is a very, very important element, my lordship. And when we don't see anything happening, then only we come to the court, my lordship.
Daku, next matter.
Item number 19.
My lord, I am for the petitioner.
Oblige, my lordship.
My lord, I am in custody.
Yes.
My lord, I am in custody for 2 years and 9 months. 5 liters of codeine mixture was recovered. My lord, my prayer for bail was rejected on 8th of February 2024. My lord, will kindly comes to the order sheets that I have annexed. Since 8th of February, what has happened before the learned court below? My lord, only 1 witness thereafter had been examined, totaling to 4 witnesses out of 13. My lord, this honorable court in a divisional jurisdiction has also directed the learned trial court to expedite the trial and my lord, conclude the same, my lord, with utmost expedition. But till date, though charges were framed on 2nd of June 2023, only 4 witnesses had been examined. My lord, from February.
How long are you in custody?
9 months. And my lord, total infraction of
prosecution could not to false production of the witnesses on 2 days, on 17/5/2024 and thereafter, 25/2024. So that manner, after passing of the order of this honorable court, we have examined on 1 witness, and now, out of 13, 4 witnesses we have already examined.
So 9 witnesses you will examine now. How long going at the rate you are going? It will take another 2 years. What was recovered?
5 liters of codeine mixture.
Sole accused.
No, yes, my lord, sole accused.
Sole accused.
Sole accused.
People.
My lord, on 15th February, no witness was present. 16th February, no witness was present. 17th February, no witness was present. My lord, my lord, in
Very reluctantly, sir, but what can we do? The petitioner renews his prayer for bail. Stop. He is the sole accused. Stop. Allegedly, 5 liters of codeine mixture was recovered from his possession. Stop. His prayer for bail was rejected first on 3 rejections or
yes,
how?
my lord. My lord, before submission of chemical report and my lord thereafter
Rejected on September 21, 2023, November 8, 2023, and February 8, 2024, by a coordinate bench. Stop. He renews his paragraph. The petitioner renews his prayer for bail on the ground of inordinate delay in progress of the trial. Stop. He says that after passing of the order dated February 8, 2024, only 1 witness has been examined. Stop. In all, 4 out of 13 witnesses have been examined till date. Stop. His fundamental right under Article 21 is completely abrogated, a fundamental right to personal liberty. Under Article 21 of the Constitution, is completely abrogated. Stop. He prays for bail. Stop. Paragraph. Learned advocate for the state says that the entire delay cannot be attributed to the state. However, there were some occasions when the delay was caused by reason of the state not being able to produce the witness. Stop. Paragraph. Whatever the cause of the delay be, it is not the case of the prosecution that the petitioner is responsible for the delay to any extent. Stop. Paragraph. Solely on the ground of delay in the progress of the trial, and since there is no real possibility of an early conclusion of the trial, keeping in mind the paramount importance of the right to personal liberty as enshrined in Article 21 of the Constitution of India, we are of the view that the restrictions in Section 37 of the NDPS Act stand overridden and the petitioner is entitled to bail.
I'm grateful, Judge.
Item number 20.
I'm for the bits. Just I'm claiming parity co-accused have been granted by your lordship, page 7.
Page 7.
Yes, ma'am. Yes, ma'am.
Commercial quantity of heroin was seized. How many years you are in custody?
3 years, 8 months.
What is the stage of the charge has been framed when? Charge sheet was filed. Shall we grant him bail?
What do you say, madam? Four? 40%. Issue. 3 years, 8 months.
3 years, 8 months.
The petitioner is in custody for 3 years, 8 months. Stop. He claims parity by referring to an order dated June 11, 2024, passed by this bench in CRM NDPS 874 of 2024. Stop. By that order, the co-accused was enlarged on bail on the ground of delay in trial. Stop. This petitioner stands exactly on the same footing. Stop. Paragraph. Learned advocate for the state says that 4 out of 10 witnesses have been examined. Stop. Stop. Paragraph, therefore, comma, there is no possibility of an early conclusion of the trial. Stop. We are inclined to enlarge the petitioner on bail only on the ground of delay in progress of the trial. Paragraph accordingly.
নয় কিন্তু ওটা 2 বলেছে 2 out of 10
Two. Oh, Baba, I was giving you more credit. The two করে দাও।
why you are not using microphone টা নিশ্চয়
Item number 21. Lordship, I beg to appear on behalf of the petitioner. So for petitioner number 2 is concerned, this is my renewal of prayer. My earlier rejection was on 27th March 2023. Thereafter, there is a change of circumstances.
And first petitioner, first application. Yes.
And after rejection,
What was recovered?
5 liters of coding mixture, commercial quantity
Joint
from
position?
each. No, from each.
From each.
I was in custody in connection with a murder case. I was taken into police custody. In the murder case yesterday, I got acquittal that I received the information from the learned advocate of the court below. And thereafter this case.
Honorable acquittal, benefit of doubt. What is it?
This has been happening.
Anyway.
And thereafter, the petitioner number 2 were interrogated. And from his possession, 5 liters of coding mixture was recovered.
Where is the earlier rejection of the petition number?
Page number 18, Lordship.
page number 18
Page number 8.
18. 180.
18. Page number ही खुजे पाई ना।
So, codeine has been recovered from your possession.
Yes.
How many years you are in custody?
Petitioner number 2 is in custody for 2 years and 8 months. Petitioner number is in custody for 2 years and 3 months. But thereafter, Lordship, 3 witnesses has been examined.
Out of?
Out of 11. Lordship may kindly seize their evidence once. I put specific question regarding.
Don't ask us to evaluate the evidence because 8 witnesses still remain. We don't know what they are going to say.
But the IO has been examined. He said that ownership of the houses where from alleged recovery has been made, that is.
What do you say to the delay, sir?
Why?
Recovery of 5 liters of codeine mixture from their possession.
We are on delay.
The last rejection was on March 2023, my lord. Thereafter, my lord, 3 witnesses have been examined, charge has been framed, and even the chemical report has been submitted. In the span of 1 year, around 1
So much has been done.
charge has been framed.
My God.
When the charge sheet was filed?
My lord, charge sheet was filed on 21st of May 2022.
2022, 21st May.
May 22.
Yes, Lordship.
2 years, 9 months. And why I is being examined so early?
That I do not know that they can explain, but he has stated he has not collected any.
The last
statement has not been sealed, Lordship.
Second last, why I has been produced so early? We are going to conclude. We are going to conclude the evidence.
My lord, if I can file the report on that.
Yes.
And Lordship, I am relying on 2 orders passed by your Lordship, where I appeared. Dispute regarding ownership. Anticipatory bail was granted by your Lordship.
We are not on that. We are not on that. Don't show us. We are on the delay. We are on the delay. No, what are they lovely?
File a report.
David. Issue. The petitioner number 1 applies for bail for the first time. Stop. The petitioner number 2 renews his prayer for bail. Stop. The petitioner number 1, paragraph, is in custody for
2 years, 3 months.
2 years, 3 months. Stop. The petitioner number 2 is in custody for 2 years,
8 months.
8 months.
Antecedents?
My lord, they are replicating the case of one of their associates. Who was
That is different.
302. There they've been acquitted.
Yesterday.
You failed to produce evidence.
Paragraph. The petitioners say that only 3 out of 11
Yes, Lordship.
witnesses have been examined so far. Stop. The evidence so far recorded also point towards their innocence. Stop. There is no possibility of an early conclusion of the trial. Stop. Their fundamental right to personal liberty under Article 21 of the Constitution is being infringed. Stop. Paragraph. Learned advocate for the state says that charge was framed in May 2022.
2023. Charge was framed.
On May 29, 2023. Stop. Thereafter, the trial has proceeded at a very fast pace. Stop. 3 witnesses were examined. Stop. Paragraph. We are unable to agree that the trial has proceeded at a satisfactory pace. Stop. In any event, comma, given the importance of the fundamental right to personal liberty, which would override any restriction under Section 37 of the NDPS Act, comma, solely on the ground of delay in progress of trial, comma, we are inclined to allow this application for bail, paragraph, accordingly.
Item number 22.
একটা জায়গায় বলে দাও, and seeing that seeing that there is little possibility of an early conclusion of the trial, we are inclined solely on the year we are inclined to.
Item number 22.
My lord, in 22 I am for the petition. This bail application was filed in 2023.
Please, bail
But
application.
yes, but unfortunately, the learned advocate, because of his absence, my lord, this was made dismissed for default. And subsequently, my lord, no communication was made, and when it was contacted, the learned advocate.
Today it stands dismissed.
Today it stands dismissed, and I have filed the application for restoration and condonation of delay.
That has been listed, yes.
Yes.
CRAN 1 and CRAN 2.
So, my lord, what happened after a lapse of considerable period of time, my lord, he expressed his desire to withdraw from this matter. The learned advocate gave no objection to the file. By that time, my lord, considerable time has already elapsed. My lord, subsequently, my lord, the petitioner, since he is in custody and the relatives are in Paschim Uttar Dinajpur, so my lord, it took certain time to contact an advocate and to re-engage him in his place. So my lord, that is the reason for delay.
Why did you not just file a fresh application? Why?
So my lord, if I could file a fresh application, my lord, that will possibly be amount to res judicata, because during the pendency of this, it is dismissed for default. That's why, my lord, I too did not take the risk of. I don't.
So, principle of res judicata is applicable in criminal proceedings.
No, that is not. But the question is, my lord, the same question of fact is already in session of the court. So, my lord, that's why, my lord.
What is the provision for restoration of bail application?
Restoration, there is no such separate provision. But the question is, my lord,
can we restore?
But since it is dismissed for default,
liberty to file
a fresh application. CRAN 2 of 2024 is an application for restoration of CRAN 2 na, CRAN 1 is an application for restoration of the bail application being CRM NDPS number 109 of 2023, which was dismissed for default on October 13, 2023, by a coordinate bench. Stop. It's a CRAN 1 bollam to. Stop. CRAN 2 is an application for condonation of delay in filing the restoration application. Paragraph. Learned advocate for the petitioner, public applicant, has not been able to draw our attention to any provision in law whereby whereby a bail application that has been dismissed for default, can be restored. Stop. Paragraph. However, the petitioner would be at liberty to file a fresh bail application, since no question of res judicata would arise, as there was no adjudication of on merits.
On merits.
Paragraph, Tran 1 and Tran 2 are accordingly disposed of. We have granted you the liberty.
My lord, I will immediately. My lord, the only one prayer I was making, my lord, since it is in Uttar Dinajpur, my lord, the order, original order.
Paragraph, last lekho, let the
same order.
Certified copy, naki let
Certified.
The certified copy.
Certified copy.
Of the order of the learned trial court,
My lord.
which is annexed to the bail petition,
My lord.
be returned to the learned advocate for the petitioner upon a true copy of the said order being furnished.
My lord.
Item number 23. Lord, I'm for the petition in this matter, my lord. Lord, this is application for relaxation of condition of bail. Lordship, petitioner was granted bail, my lord, by the coordinate bench of this honorable court, my lord, on 2nd May 2023.
শোনো they're dated,
Yeah,
sir.
Lordship, 2nd May 2023.
Yes.
Lordship, at page 8, Lordship will find that there it is submitted by the, my lord, the NDPS lawyer that the investigation is complete and charge sheet has been filed, my lord. Lordship will find at the bottom, my lord, 8 page bottom and 9 at the top, my lord. My lord, the conditions were that, my lord, the petitioner will appear on every date before the court below, and my lord, he will see the IO once in a week, my lord. He is doing that, my lord. Lord, in paragraph 3, I have stated the ground, my lord, which is compelling circumstances. Mother of the petitioner, my lord, who is diagnosed with the peritoneal carcinoma, my lord, her lungs was transplanted in 2019, my lord. And my lord, at medical doctor, my lord, at Nellore, my lord, you see advised, my lord, medical management and admission, my lord. Lord, father of petitioner is 72 years old, my lord, is unable to manage the situation, my lord, and that is why, Lord, this petition is made. My lord, the charge sheet has been filed, my lord, and my lord, investigation is complete, my lord. Still, my lord, charge as on date, my lord, charge has not been framed, my lord.
Which one do you want to be relaxed? Which
Lordship, page 9, Lordship, see. Page 9, Lordship, this is, my lord, third paragraph would be according to the petitioner, this, my lord, and my lord, last, these are the grounds, my lord, these are the conditions.
Which condition you want
Lordship,
to relax?
my lord,
Yes.
IO
All conditions.
No, my lord, to meet with the IO in every week, my lord, that is very hardship, my lord, because
Has he been doing that? Has he been complying?
That, but the ground he has taken that family. No. When investigation is completed, this condition should be waived. Passport has been returned. So my lord, passport has been returned by order of court. There is reasonable apprehension, my lord. No, he will not leave the municipal limits of Kolkata and not 24 hours. That will remain possible, my lord. Attendance once in a month because 13 kilometer away. Only 13. No. When investigation is complete, then there is no need of.
Where do you want to go?
My lord, at Nellore, my lord, because Nellore, I have annexed, my lord, the prescription, lordship, at page 58, lordship. At page 58, my lord, the doctor who
with permission of the court, you can go for certain period. You have to come back.
Then lordship may grant, my lord, the permission to that effect, and my lord, so far meeting the IO in every week, my lord, that is very harsh, my lord.
You have to show that
my lord, charge has
when charge sheet has been filed.
Till date, my lord, charge has not been framed, my lord.
Charge sheet has been filed.
My lord, prior to 2nd May, my lord, this is in the order itself.
2023. In spite of that, investigation officer wants cooperate with the investigation. Charge sheet to file.
For how long you want to go?
Lord, it may take at least 2 months because, my lord, her lungs were transplanted, and my lord, she may get admitted there, and my lord, it may take some time, my lord.
Medical documents, sir.
Lord, at page 58, lordship, see, my lord, the doctor's prescription at Nellore, my lord, 58, my lord.
There is no other male
and
member,
my lord,
apart from his father. Apart from his father, there is no other male member.
No, my lord, no male member, my lord. He's the only son, my lord. 2 daughters, all are married, 2 are married, my lord, and he's only male member, my lord.
Are you married?
Yes, married, my lord. Lord,
your wife stays here.
Yes, with the petitioner, my lord, and my lord, her son, his son, my lord, he has also, my lord, medical ground, my lord. I've stated in the paragraph also, my lord. He was premature, maybe, my lord.
He's only person, all the dependent
Page
upon him.
58 is not a prescription, medical document.
No, no, ওটা এখন দেয়া যাবে না, এগুলো দেয়া না, এই শুধু
And Lordship will see the advice at the bottom, my lord.
চলে যাবে, তখন কে দায়িত্ব নেবে? So you have been given back to the passport. You have taken.
Yes, if Lordship suggests not, he order me, he will return back the passport, my lord. He is not living, my lord. It is fact, he is not living. He will submit, my lord. He will return, my lord.
We are not satisfied with the medical certificate right now. You bring proper medical certificate, then we shall consider.
Lordship may see, my lord, that
he need not meet the IO every week anymore.
Yes.
Regarding that, I have no instruction. That means, my lord, he has complied with the.
He wants two relaxation. One, he need not meet the IO. That's what he wants. One, and then he wants to leave the municipal limits of Kolkata and not 24 Parganas because he wants to go to Nellore for mother's medical treatment. Now that we are not sure whether we should. We can dispense with
Lordship
the.
has see at page 53, my lord. This is the certificate which show, my lord, that carcinoma ovary.
Yes, we have seen. We have seen. That is not.
Page 53.
Who take her to there? 53. Why it has been examined?
Page 53. This is 2022, my lord. Long back, my lord.
53 is not any prescription.
অনেক সময় চলে গেছে।
Check up, come back. Not today. Not Thursday. Thursday, you had a group take tule debe. Not tallying, sir, with you the page numbers.
Lots.
Next.
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 Item number 24. The report may be kept with the report.
Take it back. Take it back. Come back day after tomorrow.
Please, my lords.
Yes.
My lord, custody over, my lord, 2 year, 5 months, my lord. Some of the co-accused persons are on bail. My lord, I am not exactly on parity. I am on, my lord, delay. My lord, that charge has not been framed as yet. The charge sheet, my lord, it's a complaint which was filed, my lord, on 3rd of August 2022. And my lord, I am not the main accused, my lord.
Charge not framed. Charge
not framed yet, my lord.
My lord, I'm appearing on behalf of the NCB, led by Mr. Arun Kumar Mohanty. My lord, the senior counsel is on leg on courtroom number 8. So, my lord, kindly fix the matter on day after tomorrow. The report will come from Shiliguri.
So the report was called for, my lord, in May. Kindly seize, my lord, the date. 7th of May, subject to correction by lordship.
Regarding the updates, because the last the date was fixed on 17 June for framing charge. So as per the telephonic instruction, that same date, the petitioner filed a petition. That's why the charge has not been framed. This is a telephonic.
My lord, seize the order sheets, my lord.
Mr. Bhattacharya, we'll make no progress like this. Come back day after tomorrow.
Please, my lord, I'll come back.
Adjournment is sought for on behalf of NCB.
My lord, I would not have opened my mouth since it was mentioned that we took time. My lord, I wanted to come.
NCB, stop. As requested, paragraph list this matter once again on Porshudiner date diye dao.
Most obliged, my lord. Most obliged.
25.
My lord, 25, I am for the petitioner, my lord. My lord, kindly come to the order dated 7/5/2024, where, my lord.
Yes.
My lord, there is a miscommunication in the.
You don't have the correct CD.
No. My lord, what happened on the last occasion, the coordinate bench has ordered to.
But
the next schedule, it should be to try to complete, because out of 6 witnesses, 2 witnesses has already been examined.
But the present petitioner is in custody for 2 years, 5 months.
দাঁড়াও ভাই, আমি ওই কথাটাই বলছি।
My lord, direction was given to conclude the rest of the witness on the next schedule. Now, my lord, that direction was not complied. My lord, even on the last occasion, no witness turned up. And the present petitioner is in custody for 2 years, 5 months.
Okay. Yes.
My lord, what happened, my lord, there is a miscommunication, because they have not they have not asked for the case diary, and my lord, not the report also. And over the telephone, when I contacted, they have sent this over the WhatsApp messages to that legal person. They are saying that original case diary is lying with the High Court.
Back. You did not send back.
Yes, my lord, because the legal person who is conducting, the concerned legal person, he did not take the
case there is a miscommunication, my lord. If my lord, now I'm leave it to your lordship. If your lordship
2 years, 5 months.
yes, my lord. If, I'm leave it to your lordship. If my lord grants, because next date is
How many
fixed on-
witnesses are there?
my lord, 4 witnesses are left.
No, total 6 witnesses, out of which 2 witnesses had been, my lord.
That is what he's saying. Why do you interrupt all the time? He's saying 4 witnesses are left.
My lord.
I'm leave it to your lordship. If your lordship kind enough to grant me one more chance, I will take the necessary steps to conclude.
What was recovered?
My lord, 1.4 liter, 14 bottles of fencidil.
14 bottles.
1.4 liter.
1.4
liter.
1.4 liter.
liters.
Liter, my lord.
Sole accused.
My lord.
My lord, sole accused.
What are the incriminating evidence?
But from his position.
Augustine with the suspect.
একবারে শেষ মানে
Anybody else?
আজকে আমরা হচ্ছে
আর 22 তারিখে আছে 22/7/23। I think 24th July will be sufficient for you to complete entire.
Yes, Miller. That was the earlier direction also. That for
very well. You will complete the learned trial court will direct to complete everything, including delivery of judgment, by end of August.
As you, I'm extremely grateful, man. Disposing of the.
Issue.
My lord, kindly one thing, my lord, appreciate, my lord. Charge sheet was submitted on 21/7/2022. After that, my charge was framed on 10/2/2023.
We are not going to, because it's coming to an end. We are not going to enlarge you.
My lord.
Only 2 months.
Deeply obliged.
The petitioner, read order dated May 7, 2024, paragraph. A coordinate 2024, which is to the following effect. পুরো এটা ছোট্ট order এটা করে দাও এখানে। Paragraph. The advocate for the state today says that because of a miscommunication between the investigating officer and the learned advocate for the state, no witness could be examined during the schedule fixed from June 13, 2024 to June 15, 2024. Stop. The next schedule is fixed from July 22, 2024 to July 24, 2024. Paragraph. We see from records that 1.4 liters of codeine mixture,
yes, Miller,
was recovered from the possession of this petitioner, who is the sole accused.
Fencidil, my lord. Fencidil syrup.
Fencidil syrup. Codeine mixture na kore fencidil syrup. Sole accused. Stop. There is sufficient prima facie incriminating evidence against him. Stop. Paragraph. Therefore, although the petitioner has been in custody for about 2 years and 5 months, we are not inclined to enlarge him on bail immediately, keeping in mind the restrictions of Section 37 of the NDPS Act, paragraph. However, we direct the learned trial court to conclude witness action during the next schedule and dispose of the trial at the earliest, but definitely by August 31, 2024. Stop. Naturally, the petitioner shall render all cooperation for such speedy disposal, and the state shall also not obtain any adjournment. Paragraph. Prayer for bail is thus rejected at this stage. Paragraph. We clarify that if the trial is not concluded within the time period indicated above, the petitioner will be at liberty to renew his prayer for bail.
My lord. One line may be added, Miller. Parties shall communicate this order to the.
Paragraph. Parties shall communicate this order forthwith to the learned trial court.
What about CD?
I'm depositing it today. Send. Very quick.
No, there is a process. I will deposit it in the public prosecutor's office. They will collect it. I will inform them.
Item number 26.
Madam, for the petitioner, I'm praying for bail on the ground of delay in trial, my lord. My lord, I'm a truck driver. I'm suffering cancer since 2020, my lord.
One second. Report.
Not yet. My lord, the truck driver has taken this order. Truck owner, my lord. Stay until further order, stay of arrest, my lord.
But may I say this? Well, the present petitioner here is the truck driver. From his truck, from his possession, 15,000 bottles of fentanyl were
1,500.
Sir, you were directed to file a report.
Yes, my lord. Here is the report. Now, your lordship will kindly see. The charge was framed. The evidence was recorded. In the course of the evidence, section 319 was imposed. The owner of the truck was called from Uttar Pradesh. Now, he took several adjournments. He did not turn up. The learned magistrate over there issued a warrant of arrest against him. But he challenged the matter before the High Court. He got it stayed until further orders. He did not communicate that order before the learned judge in the court below. So the trial could not be expedited. The reports, the next page clearly states that it was passed a year back by this honorable court. Neither the matter was taken up for final hearing, nor the order was communicated. Lordship will kindly seize the last paragraph.
Babulal obtained a stay.
Yes, Babulal is the owner of the truck.
Very well.
He was not charge sheeted.
Ajoy Kumar didn't obtain the stay?
No, my lord. Ajoy Kumar did
Show us how Ajoy Kumar is responsible for the delay.
My lord, Ajoy Kumar, may I say this? The trial did start. When the trial started, an application under 319, including for recalling witness of Babulal, someone was issued against him that it is your.
How long are you in custody?
3 years, 6 months. More
3 years, 6 months.
And another thing, why owner has not been made an accused?
My lord.
Why owner has not been made an accused?
My lord, owner has not been made an accused, but he was called under 319. He was called.
Witness. That is a witness.
He was called under 319. Lordship will kindly seize the orders. The orders are also annexed there. Huge quantity. My lord, he did not come after 4 to 5 occasions. He filed an application for stay over here. My lord, he obtained the stay.
Mr. Vishwash, unless you can show us that he is responsible for the delay to any extent.
Yes, my lord. Lordship will kindly turn the second page of the report, my lord. If the order is not communicated of this honorable court after receiving the stay, we cannot split up the trial and proceed against the other accused.
He has not obtained the order.
My lord, Babulal has obtained because Babulal was not coming, so an execution for warrant of arrest has been pending.
Understood that.
Well, that is being pending. Even the learned
understood everything. How is he responsible for Babulal?
Well, he is not responsible for Babulal.
What was my query?
Yes, my lord. The trial is not. The trial started. The trial started.
You may not also be responsible. You are being very defensive, and I understand why. You need not be. We are not saying that you are solely responsible. The fact remains that 3 years, 6 months, a citizen who is not a foreign national,
yes, my lord,
admittedly,
yes,
is in custody.
Yes, ma'am.
No possibility of early conclusion of trial. What would you do as a judge, keeping in mind the Honorable Supreme Court's directions?
My lord,
No, 319 has been used after trial was commenced or something.
Yes.
So why your did not arrest him during the investigation? That
my lord,
trial.
From the investigation report from the case diary, I do not find regarding Babulal. I found regarding the present petitioner Ajoy Kumar, from him the contraband was seized.
It is the duty of the investigation of
the driver.
Yes, ma'am. Yes.
3 years, 6 months.
Issue.
Residence of?
My lord, UP, my lord. Uttar Pradesh. I'll stay in West Bengal, my lord.
Yes.
Is the local address?
Yes, ma'am.
Will not relieve the territorial limits of the state.
Yes, ma'am.
Why do you
First prayer or renewal?
First renewal, my lord.
Last rejection?
My lord, page number 10, my lord.
Page?
Page number 10, my lord.
10. The petitioner renews his prayer for bail, which was rejected earlier by a coordinate bench by an order dated January 20, 2023, passed in CRM NDPS 85 of 2023. Paragraph The petitioner is the driver of the vehicle wherefrom allegedly commercial quantity of narcotic substance was recovered.
1500 bottles of fentanyl.
Bracket লিখে দাও 1500 bottles of fentanyl. Stop.
15,000 bottles of fentanyl.
15,000.
15,000.
1,000 bottles. Stop.
100 ml each.
In view of the restriction in section 37 of the NDPS Act, comma, the coordinated bench had rejected his prayer for bail. Paragraph. In the present application, comma, a coordinate bench had passed an order dated May 9, 2024, directing Learned Counsel for the State to submit a report, তারপরে quote করো, with regard to status of the proceeding and reason for delay, unquote. Stop. It was also directed that the report shall disclose whether revisional proceedings preferred by co-accused Babulal is pending before this court or not. Paragraph. Such a report has been filed today. Stop. Let the same be kept with the records. Paragraph. We find from the report that Babulal has obtained a stay of the warrant of warrant of arrest issued against him since he did not respond to the notices under
The section 319.
section 319 CRPC. Stop. Learned advocate for the state says that the delay in the progress of the trial cannot be attributed entirely to the prosecution. Stop. Paragraph. That may be so, comma. However, it is also true that the prosecution has not been able to demonstrate that the delay is attributable to any extent to the present petitioner. Stop.
Only one thing, even after granting of the stay, the order was not communicated before the learned court below.
Who will communicate, sir?
The accused, the Babulal, against he challenged the order.
How is it attributable to him?
If he would have communicated the order before the learned court below, the trial would have started.
He is not a party. Even in
মুশকিল
the
আচ্ছা আচ্ছা
proceeding.
এসো কি holo?
Sir, why he is not arrested?
To the present petitioner. Stop. Paragraph. The petitioner is in custody for a very long period of time. Stop. Very the long period of time. Stop. We cannot lose sight of his fundamental right to personal liberty and receive speedy justice. Stop. A citizen cannot be kept in incarceration for an indefinite period of time only on the ground that there is delay in completion of the trial. Stop. Paragraph. Solely on the ground of inordinate and inexplicable delay in progress of the trial, comma, we are inclined to grant bail to the petitioner.
Subject to certain conditions.
Yes. Subject to stringent conditions. বলে সব দেবে।
He shall not leave the jurisdiction of Asansol, okay, and shall give the local address to the
আসানসোল ওটা add করে দেবে।
investigating officers.
Yes. Jurisdiction of Asansol.
Yes, so Asansol.
State of Asansol কি district এখন?
District.
The territorial limits of the
Then Paschim or
Paschim
Purbo. What is that?
Paschim Bardhaman, Jamuria police station.
Paschim Bardhaman.
কি বুঝলাম না।
এখন আসানসোলটা পশ্চিম বর্ধমান ডিস্ট্রিক্ট হয়ে গেছে।
ও
ডিস্ট্রিক্ট
তাহলে ডিস্ট্রিক্ট পশ্চিম বর্ধমান করে দিও। হ্যাঁ। The pending in Asansol court. কি বললাম আমরা?
He shall furnish the details of his residential address to the.
Yes, current address. Details of the petitioner's current address will be furnished to the learned trial court. আর ওই একটা প্যারাগ্রাফ তোমরা দিচ্ছ তো প্রত্যেকটা অর্ডারে যে in case of breach of any of the conditions হ্যাঁ, without সব অর্ডারে থাকবে ওটা। হ্যাঁ।
Grateful, my lord.
27.
My lord, I'm for the petitioners. My lord, this is a renewal application in respect of both the petitioners. The petitioner bail for lastly rejected on December 2023. Thereafter, there is a change in circumstances. The person from whom the recovery was made, she has been granted bail by the Honorable Apex Court. And from our position, nothing was
No,
recovered.
on the what ground? Delay?
On the ground of delay, my lord.
How long have you been in custody?
We are in custody for more than 2 years, 4 months, and from whose position the recovery was
Where
made.
is that order?
My lord, kindly comes to page 19 of my application. That person was in custody for 2 years, 3 months.
For
2 years, 3 months.
2 years, 3 months.
That person, and we are in custody for more than 2 years, 4 months.
39, I think the same. 39.
Please don't confuse us.
Page 19, my lord, of my application.
Yes, 3 months. How many witnesses has been examined?
Out of 16, 6 have been examined. And today is the date fixed for trial. Trial is going on.
So there's a change of
My lord, from
change of circumstances in favor of the prosecution.
my lord, from
Not
our
in your favor.
position, my lord, subject to lordship.
There was no witness examined at the time, at that time. However,
My lord, so far, the order sheets, as per my instruction, my lord, the first schedule is fixed on 23rd of July. The first schedule is fixed.
That was preponed.
6 witnesses have been examined. Show him that
Witnesses have been examined. And Lordship, see page 17, the order of rejection, 4 times page rejected.
Yes, my lord, this is my renewal, but from our position.
Tell us one thing. The Honorable Supreme Court's order is dated 26th of April 2024. It is recorded in that order that as on that date, not a single witness had been examined out of 16. So since 26th April 2024, how many have been examined?
6 have been examined. Because
6 out of 16.
Out of 16. And today is the date fixed for trial. Evidence going on.
you do not have the instruction.
My
They
lord,
are not on the same footing. They were operating from the jail. And see the coordinate bench order.
My lord,
Entire operation was going from the jail. Trafficking, gazettes, then there was a report to conduct an inquiry. That was done.
You come back with instruction as to today only or today and tomorrow. What is fixed for? Come back day after tomorrow. Report to us. Let us see what is the progress.
and my lord,
Learned advocate for the petitioner, in support of the prayer for bail, relies on an order dated April 26, 2024, passed by the Honorable Supreme Court, granting bail to a co-accused person. Stop. Paragraph. In that order, the Honorable Supreme Court recorded that not 1 out of 16 witnesses had been examined. Stop. Paragraph. Learned advocate for the state today submits that after that order of Honorable Supreme Court was passed, 6 witnesses have already been examined by the prosecution. Stop. Today and tomorrow are dates fixed for further examination. Paragraph. To see the progress and the bona fides of the prosecution, we direct this matter to be listed again on Porshudiner date diye dao. Or you want it on Friday? No, Friday to on Thursday. Date diye dao. Stop. Learned advocate for the state shall apprise us of further developments, if any, on the next date.
And 39 same.
27 and 39. You are appearing in 39.
my lord, I am not appearing.
Petitioner is not raped. Let it be called on.
Appearing for the same.
No. Oblige, my lord.
Item number 28.
Paragraph for the petitioner. My lord, nothing has been recovered from me. Co-accused statement. I am in custody for 1 year, 1 month.
Co-accused has been granted.
Granted bail.
Nothing has been recovered.
Which is that Sabir Ali? Paragraph. The petitioner claims parity. Stop. He says that a co-accused was granted bail by a coordinate bench by an order dated March 5, 2024. March 5.
My lord, I don't have that order, my lord.
In CRM, please tell us, March 5. CRM NDPS 432 of 2024. Is it Sheikh Shabir Ali? Ah, fine then. 432 of 2024. Stop. Paragraph, learned advocate for the state in his usual fairness admits that this petitioner stands on the same footing as Sheikh Sabir Ali. Stop. Hence, we are inclined to allow this application. Paragraph accordingly.
29.
Item number 29, I'm for the petitioner, my lord.
They dekhi. Personal liberty.
My lord, on the last occasion, your lordship sought for a report from the trial court, my lord, that this matter is, my lord, is moving from Chief Judicial Magistrate to, my lord, learned Session Judge, and Session Judge to Chief Judicial Magistrate, my lord. Because when FIR was lodged, my lord, it was under Drugs and Cosmetics Act, my lord. Ping pong, my lord. Drugs and Cosmetics Act, my lord. My lord. May I?
My lord.
Yeah, my lord. My lord. During the pendency before the learned Chief Judicial Magistrate, my lord, two accused persons, my lord, Abdul Khalek and Anikul Sheikh, my lord. From their possession also, my lord, 25 bottles of fencidal recovered, my lord. They have been granted bail by the learned Chief Judicial Magistrate, my lord. Petitioner is also standing on same footing, my lord. Though my application for bail has been rejected by the coordinate bench, my lord, in the month January, my lord, on the ground that charge sheet has been submitted, my lord, under NDPS Act, my lord. But thereafter, my lord, it's a ping pong, my lord. From here to there and there to here, my lord. I'm in custody for, my lord, around 10 months, my lord. No progress, my lord. My right to speedy trial has been seriously infringed, my lord.
My lord, may I? Initially, the case was started under Section Drugs and Cosmetics Act. Your lordship is well aware of the fact that the Drugs and Cosmetics Act, it's not a special act. NDPS Act, Narcotics, Drugs and Psychoactive Substances Act, is a special act. On a special law generals the general law. If your lordship kindly have a look into Section 80 of the NDPS Act.
What do you say regarding his claiming parity?
My lord, these
two co-accused have been granted bail by the Chief Judicial Magistrate.
My lord, the Chief Judicial Magistrate, with deepest respect, he doesn't have the power to entertain this matter because it's a case under NDPS Act which has to be entertained by the Court of Sessions or a special court.
Have you prayed for cancellation of bail?
Now, my lord, in the lower court, what I have gathered knowledge, my lord, and cancellation of bail which is pending before the Court of Sessions. Now, what I'm trying to apprise your lordship, my lord, will kindly Section 80 once there I will come.
81.
80. This is a case of 2021. These persons has been absconded for 2 years. In the year 2023, he has been taken into the custody.
No, my lord, I have surrendered.
Allow him to speak.
Tendering apology, my lord.
81.
My lord, Section 80.
Section 80.
Yes. My lord, the spirit of this section says that the my lord has got it? Yes. My lord, the spirit of this section says Section 80 of the NDPS Act lays down that the application of the Drugs and Cosmetics Act 1940 is not barred. And the provisions of this act or the rules made there shall be in addition to, not in derogation with. So the NDPS Act prevails. My lord, the charge sheet has been submitted in NDPS Act along with Drugs and Cosmetics. Now, my lord, the factum of the case. My lord, in a house which belongs to the petitioners, a huge quantity of codeine mixture has been recovered. Now, my lord, from the seizure list as well as from the petition drafted by my landlord from the cause title, my lord will get the same address. Now, 2 years he has been absconded. He prays for an anti-suitary bail. That has been turned down. And my lord, my landlord friend will not show from a single order that the landed additional session judge is returning back this case to the CGA. It's not there. We have filed the report, that's why. So your lordship has every power to direct the additional session judge to take cognizance and to frame the charge. My landed friend has never agitated this point before the divisional court. Never.
Additional session judge or the special court?
Special court is a special court.
Additional session.
No, there is designated special court.
Special judge. Now, but
Your lordship rank of additional district judge.
Deeply.
Okay.
He basically is agreed because it is a stalemate.
Deeply.
So therefore, we will direct.
Yes, Section 37 will not overcome this prospect.
Anything you have to speak?
My lord, my learned friend said,
You
my
will
lord, that
expedite the entire thing, sir. 10 months. Very
10
well.
months, my lord.
You can always come back after a reasonable period of time.
But then kindly frame a time word, my lord.
Frame, how come? Let the
Issue.
charge be framed.
Issue.
Framing of charge, not framing of.
By an order dated June 12, 2024, we had called for we had requested learned advocate for the state to obtain instructions as regards the present status of the case. Stop. Paragraph. Today a report has been filed. Stop. Let the same be kept with the records. Stop. Paragraph. It appears that charge sheet has been filed under the provisions of the Drugs and Cosmetics Act and the NDPS Act. Stop. The matter is pending before the special court. Stop. Learned advocate for the state says that there is nothing on record to show that the matter has ever been sent back by the special court to the court of the Chief Judicial Magistrate. Stop. Paragraph. Learned advocate for the petitioner says that the basic grievance of the petitioner is that his right to speedy trial is being infringed. Stop. For 10 months he is in custody. Stop. Beyond filing of charge sheet, nothing has progressed. Stop. Paragraph. In view of commercial quantity of contraband being involved, we are not inclined to enlarge the petitioner on bail at this stage. Stop. However,
In view of section 80.
No, it's 89. In view of section 37 of the NDPS Act. Stop. Paragraph. However, the petitioner cannot be detained indefinitely. Stop. He is already in custody for 10 months. Stop. The special court is directed to
Special court under NDPS.
special court under NDPS Act,
Kindly mention the status of that court, 4th ADJ.
Special
Fourth
court,
ADJ.
court Malda, my lord.
special court under the NDPS Act bracketed the 4th ADJ.
ADJ কোন court বল?
Fourth court Malda.
ADJ 4th court Malta.
ADJ, 4th court, Malda. Bracket closed. To
take cognizance and
take cognizance and proceed with the matter in accordance with law as expeditiously as possible.
This has to be done.
So that the trial can come to an early conclusion.
Extremely.
My lord, kindly pass a direction, my lord, to the learned special court, my lord, to frame the issue of charge, my lord.
Cognizance
The cognizance and proceed in accordance with law.
You are Mr. Wasim Akram.
Yes, my lord.
Wasim Akram.
Yes, my lord.
You play cricket?
Yes, I used to, my lord, when I was in the law college, my lord.
Left arm?
Oh, right.
Deeply obliged.
Great.
এই আমার বইটা একটু দিও না।
Item number 30.
30, my lord. This matter was at last occasion, and your lordship directed me to file supplementary affidavit. My lord, this is my supplementary affidavit. Matter, my lord, matter, lordship kindly have a look into first supplementary affidavit. এটা দিন না একটু। My lord, this court granted bail to the petitioner.
Have you received copy?
Yes, my lord. That is, my lord, if your lordship kindly come to main petition, my lord, page 11, this court granted bail to the petitioner. But on the specific date, the petitioner unable to present before the learned trial court. For that reason, my lord, production warrant was issued. That time I mentioned the petitioner that time was arrested in connection with another case before Bardhaman. And your lordship directed me kindly produce the memo of arrest of that case and when granted bail. For that reason, my lord, supplementary affidavit. My lord, supplementary affidavit, my lord, first page 6, in connection with 399-402 case, present petitioner Sanjeev Singh was arrested on, my lord, column number 2, date of arrest, 4th March 2023. in connection with, my lord, Bardhaman PS case number 288/2023, 25 February 2023. Memo of arrest.
Go through the entire.
We'll go through these papers, come back tomorrow at 1 p.m. 1 p.m. tomorrow. Come back.
Tomorrow.
এই কাগজগুলো পাঠিয়ে দাও আমাদের কাছে। To cut the matter short, Mr. Chattopadhyay, let us go through the papers and come back tomorrow. Hey, Esho, lekho.
Nothing was seized from him in this.
Supplementary affidavit filed by the petitioner in terms of liberty granted by us, comma, be kept with the records. Paragraph. List this matter once again. Kalki, dekhe nao, kalki. Ache to? Kalki date diye deo, mark 1 p.m. পাঠিয়ে দাও।
31. Lord, I am for the petitioner. Lord, this petitioner is in custody for 2 years and 7 months. My lord. A report was called for, my lord.
2 years?
2 years, 7 months. My lord, out of 12 witnesses, 5 has been examined. And the prosecution has prayed for a recall of PW1. Since then, he is not appearing.
Investigating officer already examined. They are stated in the report, lordship. They are never examined any further witness. Consequently, see last line, lordship.
Oh, after re-examination, you will conclude.
Oh, he'll conclude. No further examination.
No further.
If that is the report, I cannot stand.
So therefore, what is it?
Give me a copy of that report.
So in that event, we will direct the trial court to deliver judgment by the end of August.
Yes, lordship.
Yes, ma'am.
End of August. Yes, sure.
The next date is on 29th of July.
Thereafter, lordship.
Yes.
After 3 months.
Pursuant to our, no 3 months.
1 month.
No.
Conclusion of
Argument, date of argument, lordship.
Whatever it is, by the end of August. 2 years and 5 months.
2 years, 7 months and 6 days.
7 months. Pursuant to our earlier order, comma, who is the special PP, comma, NDPS, has filed a report dated June 23, 2024. Aajke koto tarikh? Acha, 2024. Stop. Let the same be kept with the records. Paragraph. From the report, it appears that 5 out of 12 witnesses mentioned in the charge sheet have been examined. Stop. July 29, 2024 has been fixed as the date for examination of PW1 on recall for proving Durgapur PS GDE number 980 dated 18/11/2021. Stop. The report says that on that date, the prosecution evidence is likely to be closed since the prosecution will not examine any further witness. Paragraph. In view of the aforesaid, paragraph. In view of the aforesaid, comma, since the trial is on the verge of conclusion and commercial quantity of contraband item is involved, comma, we, comma, though not inclined to grant bail immediately to the petitioner, comma, direct the learned trial court to dispose of the trial by delivering judgment by August 31, 2024. Stop. Paragraph. We clarify that if the trial is not concluded by the date indicated above, comma, the petitioner may renew his prayer for bail.
I'm great.
Next.
32.
My lord, kindly takes up the order dated 12 June passed by your lordship just before the last order. More than 2 years in custody. Out of 12, only 1 witness have been examined. Charges in December 2022.
Charges has been on.
No, report has been called for, my lord.
Report submitted.
But I have seen the report. polite way to say, my lord, lackluster performance by the prosecution. 1 year, no witness has been acted.
You are in custody for?
My lord, 2 years, 11 days.
So only 1 out of
12.
12 has been examined. You let him go what to do.
My lord,
Esho.
I will stand in the.
Pursuant to our order dated June 12, 2024, a
special
এটা কি? Memo of evidence.
Report, please.
Memo of evidence.
Memo of evidences and status of trial. ওই ছোট করে list of the case লিখে ওইসব করেছে।
কি লিখবো আমি? Report লিখবো না?
Report.
A report has been filed on behalf of the state. Stop. Let the same be kept with the records. Stop. Paragraph. It appears from the report that during the last 1 year, not a single witness has been examined.
Not a single.
It is very specific. I am ashamed of some.
Till date, although charges were framed on December 23, 2022, till date only 1 out of 12 witnesses has been examined. Paragraph. Such delay in progress of the trial cannot be countenanced. Stop. The under trial cannot be kept indefinitely in custody without taking the trial to an early conclusion. Stop. Every citizen, including a charged person, has a right to speedy trial. Paragraph. Accordingly, solely on the ground of undue delay in progress of the trial, which would override the restrictions in Article 30, in Section 37 of the NDPS Act, we are inclined to grant bail to the petitioner.
Not to leave Pultoli PS jurisdiction.
Not to
leave. And local address.
কি কোন
Which one is the local?
জেনে নাও বাবা জেনে
Pultoli police station. South 24 Parganas. Baruipur. Baruipur. Pultoli PS jurisdiction.
My lord, grateful to you.
Next.
33.
My lord, I am for the petition. My lord, the petitioner is aged about 19 years. And my lord is a patient of epileptic disorder that is at page 9. My lord, if your lordship kindly comes to page 9. My lord, in this case, 100 bottles of fencidril was recovered. I am in custody.
Chemical examination report.
My lord, report is
Submitted with the court.
Supplementary charge sheet has been filed, my lord, with chemical report.
Positive report.
Codeine.
My lord, I am only, my lord, praying for bail, my lord, on the ground of the medical condition of the petitioner.
How long in custody?
My lord, 4 months. Since February 2024. I am a
My lord, in the entire order sheet, my lord,
I am, my lord.
He never claimed, my lord, before the learned court below that he is a patient.
Suddenly he has fallen ill.
No, my lord, since 2015, page 9. My lord, 19 years old. I am only.
What document do you have?
My lord, page 9 onwards.
2015.
You will direct the hospital.
Yes. 2015.
Since
attend to you.
Since 2015, my lord, it has been detected.
Direction of the correctional home.
My lord,
Superintendent.
And my lord, only if the trial.
Which correctional home?
Dum Central Correctional Home.
Superintendent.
We'll direct the superintendent to.
My lord, if the trial can be concluded within a time bound period.
No time bound.
4 months only.
Yes, 4.
But
as your lord.
Issue.
As your lord.
Allegedly.
Charge sheet has been taken.
Yes, charge sheet, supplementary charge sheet. Both
Commercial quantity of contraband item was sole accused.
Yes, my lord.
Recovered from the possession of the petitioner, who is the sole accused. Stop. Paragraph. By an earlier order dated May 30, 2024, the state was directed to take immediate steps for submission of chemical examination report. Chemical examination report capital before the learned trial court. Paragraph. Today, the state says that the same has been done. Stop. A copy of the report has been placed before us. Stop. Let the same be kept with the records.
Supplementary charge sheet, man.
You have not given us report.
No, no.
Oh, tell a copy.
Supplementary charge.
Copy the chair though. It is stated that after the report came, supplementary charge sheet has been filed since the report has tested positive, since the samples have tested positive. Paragraph. The petitioner says that he is a chronic patient. He needs urgent medical attention. On that ground, he should be enlarged on bail on whatever condition the court may decide. Paragraph. Learned advocate for the state opposes the prayer. He says that all medical facilities may be made available to the petitioner by the government hospital.
Inside the hospital.
By the hospital, that is to which by which hospital?
Dum Central Correctional Home, well, it has its own legal setup.
By the hospital operated by the Dum Central Correctional Home. Paragraph. In view of commercial quantity of what is it? What was
100 bottles of Fencidrine.
Commercial quantity of contraband items being involved. Keeping in mind section 37 of the NDPS Act, we are not inclined to allow the petitioner's prayer for bail. Paragraph. However, the superintendent of Dum Central Correctional Home is directed to arrange for all medical facilities for the petitioner as he may require, and to ensure that there is no and to ensure that he receives full medical attention.
That's all.
I'm grateful.
Expedite.
My lord, expedite.
Paragraph. Likhe dao. We further request the learned trial court to expedite the trial to the extent the business of the court may permit.
I'm grateful, General.
Item number 34.
Well, I am for the petitioner.
State.
Well, here there is a conflict of opinion of these of two coordinate benches. Well, on the last occasion it was submitted. Well, of one co-accused person has been granted bail. That is at page 20.
These are appearing for the state.
Not today.
Grateful to you.
Or Passover will mean nothing really.
As your lordship's convenience.
Not today.
Grateful to you.
35.
35 for the state.
Well, I am for the petition.
What do you say?
Well, nothing, no contraband was recovered from the petitioner on the basis of
Accused statements. He was arrested from Karnataka.
Oh.
Dates have been fixed for evidence on 3rd of.
How long in custody?
Well, I am in custody for 8 months.
Contraband of
Chance of
750 ganja was recovered, but not from them.
Not from
Not
him.
from
There is chance of abscondence.
my lord, because he's
There's
a
nothing recovered from the possession of the
he's from New
petitioner.
Barakpur
Well,
area,
Only the organized crime.
my lord, and
This is a question to him. This is organized crime.
My lord, 37 won't be attracted. My lord, I will not.
This is our discussion.
My lord, as you. My lord, I will not leave the jurisdiction of not to be
Yes,
not
that is
24.
the that should be the
My lord,
submission.
not very
I will
strange
not. I will
investigation.
not leave the jurisdiction of
The
not to be.
mobile phone of the petitioner was not seized, so to check the CDRs. Then the neighboring statements were not recorded.
That is not
We
his
have not,
problem.
my lord, I'm just saying. So we
My
have
lord, I
nothing to say, but he was arrested from Karnataka. The case is of July 23
How long in
and he
custody?
was
is it?
taken into custody in October 23.
He shall not leave the
Jurisdiction
jurisdiction
of not to be not 24.
Fine.
Report to the
Yes.
police every week.
Yes.
Attend every hearing. Issue.
I'm sorry, I know this.
The petitioner says that he is in custody for 8 months. There was no recovery of contraband items from him. Stop. He has been implicated solely on the basis of statements made by co-accused persons. Stop. Charge sheet has been filed.
Yes, my lord.
Upon completion of investigation. Stop. He may be released on bail on such conditions as this court may decide. Paragraph. Learned advocate for the state says that the petitioner was arrested from the state of Karnataka. Stop. However, comma, it is true that there was no recovery from him. Stop. He has been implicated only on the basis of statement of co-accused persons. Stop. There is every chance of the petitioner absconding if enlarged on bail. Paragraph. Charge has not been framed.
Charges framed next date 3rd of August for evidence.
3rd of August. How many witnesses?
33.
33.
My lord, very progress is good enough.
We find that
Case of July 23.
we find that
international record.
charge has been framed and
International record.
July 23. Sorry.
3rd of August is the next date for evidence.
August 3, 2024 has been fixed as the date for recording evidence. Stop. We are told that there are 33 witnesses. Stop. Huh?
8 months.
There does not appear to be any possibility of the trial concluding at an early date. Stop. In any event, comma, since there was no recovery from the petitioner, comma, we are of the view that the restrictions in Section 37 of the NDPS Act would not apply. Stop. We are inclined to grant bail to the petitioner, but on stringent conditions. Or likhe debe, not to leave the jurisdiction of North 24 Parganas.
Give the local address.
Correct. My house is in New Barakpur, district, not 24 Parganas.
You will give your local address to the trial court and report to the आयो तो नहीं है, चार्जशीट तो है यार.
Officer in charge of Modhamgram Police Station.
Officer in charge,
Modhamgram South Police Station.
Station every week.
Bye.
Until
Just
further
add
orders.
one line that the case involves recovery of 759 kgs ganja. Though not from this,
759.
but 759 kgs. Huge quantities.
তাহলে এখানে the learned advocate for the state ওখানে গোরাতি বলো says that the case involves recovery of 759 kgs of ganja. চিন্তা করো.
I'm grateful.
36.
Endorsement.
এটা কি 35 হলো?
Yeah, please, Your Lordship. Your Lordship, I'm reading for prayer for bail. Your Lordship, on the earlier occasion of 12th of April 2024,
You are for?
Your Lordship, this petitioner's bail was turned down by the coordinate bench only because the time frame of 1 year.
Page,
Your Lordship.
12th of April, it was
12th of April, on the ground that it was a premature one and the trial was not, 1 year had not
Tell
elapsed.
us the page, sir. Allow us to read also, madam. Which page?
Your Lordship, the page nation is after this orders, Your Lordship. The page 17.
11th of May.
12th of April 2024.
That has been rejected, but previous.
On the ground that with the 1 year was not completed because the earlier rejection was 11th of May 2023. It was a premature one. On that ground, Your Lordship,
How many witnesses have
My lord, only 3 witnesses are remaining. We have filed a report and we have, my lord, indicated in the report that we'll take maximum, my lord, 2 to 3 months to finish the entire.
dates the
We have,
prosecution
my lord, put it in writing in the report.
incriminating evidence against this?
My lord, it's a commercial quantity. It's a commercial quantity. Section 37 in this case applies. Twice it has been rejected by this honorable court on merits. And on the last occasion, on 2 months ago, my lord, this honorable court held that the court is not inclined to consider either on merit.
Twice rejected on merit.
Twice rejected.
Once.
First one was on merits,
Second
12th of
also
May.
premature
Then, my lord, 12th of
Second one because the time period was not over.
Kindly see the last sentence. Under such circumstances, we are not inclined to grant bail either on merits or on the ground of delay. So twice rejected on merits.
How many are examined.
My lord, the fourth witness, there are in total 7. The cross-examination of the fourth one is going on. My lord, we have filed a report, my lord, indicating that we'll finish the entire trial in 3 months. We have specifically undertaken
Next
that.
date, next date.
5th of August.
7 days. The
5th of August is the
no
next date.
witnesses were present.
No, not it won't do by finishing your examination. The trial
Entire
has to be
exercise.
disposed of within
Entire
3.
exercise.
Entire
We'll
exercise.
finish off.
No
From
witnesses.
3 months, my lord, from the next date fixed, my lord.
Issue.
Your Lordship, no witnesses were present as reflected from the orders.
We are making it totally time bound. We are also saying that if they can't do it, come back before us with your prayer for bail. Allegedly, commercial quantity of contraband item was seized from the possession. Sole accused.
2 accused.
Possession of the petitioner and a co-accused person. Stop. The petitioner's prayer for bail was rejected on merits by a coordinate bench by an order dated May 11, 2023, passed in CRM NDPS 957 of 2023. Stop. The coordinate bench had it had not said 1 year, right? Did it say 1
In
year?
the 12th May order.
12th May order reflects, Your Lordship.
12th May.
12th April.
23.
By the said order of trial court was directed to conclude trial within 1 year.
No, in the 11th May order, but that is not there in my copy because the last part has not been photocopied. So if my learned friend has a better copy, she can hand up to the court.
11th May order also did not say 1 year.
12th April your order reflects. But
You're not following, madam.
there was no such.
There was never any direction.
I was not speaking, but in the 12th April your Lordship.
Yes, that is perhaps not correct.
Well,
কি বললাম? Rejected on merits. Huh? The petitioner renewed his prayer for bail by filing, at a paragraph, filing CRM NDPS 648 of 2024. Stop. That application was dismissed by the coordinate bench. Was also dismissed by the coordinate bench. Stop. Paragraph. Learned advocate for NCB says that 4 out of 7 witnesses have been examined.
3, Your Lordship.
3 in total. The 4th.
3 out of 7 witnesses have been fully examined. Stop. The 4th witness has been examined in part.
Lordship.
Stop. The next schedule for examination has been fixed
On 5th of August 2024.
on August 5 to
2024. This
August 5 to August 7. Only one
year.
day.
No, Lord, only one date is fixed.
One date.
On August 5, 2024. Stop. You have filed a report.
Lordships. And we have said the trial is likely to be concluded in 2 to 3 months.
A report has been filed on behalf of NCB in court today, which inter alia says that the trial is likely to be concluded within 2/3 months. Paragraph. We direct the learned trial court to conclude the trial by delivering judgment by September 30, 2024. Stop. Paragraphs. Since commercial quantity of contraband item is involved, we are not inclined to allow the petitioner's prayer for bail, at this stage, stop. However, if the trial is not concluded by delivery of judgment within the time period indicated above, the petitioner would be at liberty to renew his prayer for bail.
Can it be November 2011?
No,
Because,
Mr. Judge.
because the date is on.
How long are you in custody? How
Your
long?
Lordship, 2 years, 10 months.
2 years, 10 months.
Very. I'm deep.
37.
My lord, my application. My lord, the petitioner is seeking bail principally on the ground of his detention, which is more than 1 year, 8 months. My lord, out of total proposed witnesses, the 13 numbers, My lord, one has been examined till date. My lord, may I take your lordships once to the orders which I have annexed to
Any
my
rejection
lord?
earlier?
My lord,
Any
no.
rejection?
My first application, my lord, from February
What
6th.
will you tell us? 1 year, 8 months? Let them explain now. Yes. What was recovered?
My lord, 300 bottles of fencidil. Me is the driver of the vehicle. My lord, only thing is that from February 2024, only one witness is examined. Thereafter, no witnesses are
Charge was
turning up.
framed on?
Charge was framed on in the month of September 2023. Thereafter, it commenced from February. Now, only one witness, he has turned up, his examination is over.
Two witnesses have been examined.
No, I have annexed the order sheets.
2 out of 13.
2 out of 13. Only
Are you
two
sure?
schedules have been, the next schedule is fixed from 3rd of August to 6th of August, for 3 more witnesses. It will be completed within 6 months or so.
How can it be?
Hardly.
My lord, in case it is completed by 6 months, I am not praying for any bail, my lord, because
saying
there are altogether 13 witnesses. My instruction is only one is examined. Anyway, two. If they can examine other 11 by 6 months, I am not praying for bail for the
So
time.
we'll record the.
Let me come back after 6 months.
So what do we do? We'll record their statement. But
He is a junior.
But you
My lord, we are.
we will give them a time bound program.
Are you sure you are making tentative? Don't make such statement. Tentative. Make sure, else, my lord, may I rely on one of the order of the Honorable Supreme Court. My lord, where is 1 year, 2 months Supreme Court granted bail? I am also on the same footing.
No.
But 6 months, my lord, indicate.
Is in custody for 1 year, 8 months. 1 year, 8 months.
1 year, 8 months.
8 months. Stop. He says that only.
My lord, for once, may I? For the satisfaction of my learned junior. May I?
Only,
kindly do not take me wrong.
Only 3 out of 13 witnesses have been. 2 out of 13 witnesses have been examined.
My lord, kindly see here the punch witness, the scissor witness is already examined. Here, my lord, second page. There 4 witnesses were examined. Third sentence. Punch witnesses, PW 3, 4, all were examined. Now, kindly turn a leaf. Turn a leaf. Just for a moment. My lord, kindly turn a leaf. The paragraph starts with now on examination of the punch witness. We have, but there are some certain reservations. Thereafter granted.
Come back at 2 o'clock.
My lord, on conditional apology, my lord, under compelling circumstances, my lord, this matter is again not in the list. And your lordships had directed the personal appearance of the investigating officer, my lord. He's present, but the matter is not in the list, my lord.
বারবার বাইরে থেকে আসছে এক্ষুনি নিয়ে আসতে বলতে হবে এই 2:30-এর মধ্যে 2:30 বা 3টের মধ্যে নিয়ে এসে রেকর্ডটা হয় না আগের দিনও এসে ঘুরে গেল
কেন হচ্ছে এটা? হ্যাঁ? We'll come back maybe 5 minutes late.
এখন সাজেশন জিজ্ঞেস করবো
জানি যে এটা একটা
My lord, with that, kindly allow me to rely on the order passed by your lordships. My lord, it is pat on the point. In this order also, my lord, the accused was in custody for 1 year, 10 months. Similarly circumstances, I am also in custody for 1 year, 10 months. There, 11 witnesses were there. In my case, 13 witnesses. Well, passed by your lordships only. The Supreme Court judgment as well. But in the Supreme Court judgment, my lord, he was in custody for about 2 years. In my case, I am in 1 year, 10 months. And my lord, the judgment passed by your lordship, I am covered by this in toto.
Subject to correction, my lord, I don't know about the seizure, my lord. My lord, so far as this petition is concerned, my lord, first of all, a car was apprehended. My lord, 2,000 bottles were seized.
200.
2,000 bottles of fencidals were seized from that car. Later on, my lord, from the statements of the localites, it came to know that this petitioner was the driver of that vehicle.
No.
Then he was apprehended. Then, leading on his statement, my lord, 300 more bottles were recovered.
No. Leading on the statement of one dealer on one, subsequently one person was arrested. My lord, this has got no connection with the merit of the case. This is all about detention. My lord, that was the consideration before your lordship in the earlier case, which I have handed over.
The charge was framed?
My lord, in the year 2023, month of September.
25th of September 2023. Thereafter, 2023. Thereafter, my lord, 2 schedules were given. My lord, one, there was no witness present, and on the other, my lord, 2 witnesses have already been examined. But upon instruction, my lord, I am submitting from the next date of evidence, my lord, within 6 months, my lord, the trial will, my lord, the evidence will be complete.
My lord, I have annexed
Evidence will be complete, my lord, from the next date of evidence.
My lord, I have annexed the order sheets till 17th May 2024. Till that day, my lord, only one witness was examined.
Another.
My lord, I am relying on this and I am leaving to you, lord.
Declaration of loan.
There are 2 charge sheet accounts.
My lord, may I be released on stringent conditions, whatever, on stringent conditions.
Wait for 6 months.
Witness action has not yet begun. You have referred our decision, witness action has not yet begun. That means
Yes, but in my case, only one. My lord, that is his submission, but my lord, my records was anyway. No issue. My lord, in that event, kindly record that within 6 months, that is what my learned friend submitted. Kindly
From the date of evidence.
Issue.
Right.
You are the sole accused.
No, there
are 2. One is absconding.
I am on.
Huh?
One is absconding as of now.
The petitioner is one of 2 accused persons
It has been splitted up.
from whom commercial quantity of contraband items
The junior
seized. Stop. The petitioner is agreed by the fact that he is in custody for 1 year,
10 months and above.
10 months, for more than 1 year, 10 months, more than 1 year, 10 months. Stop. According to him, only 1 out of 13.
2 out of 13.
13 witnesses. Only 1 out of 13 witnesses has been examined till date. Stop. His fundamental right to personal liberty is being infringed. Stop. He prays for bail. Paragraph. Learned advocate for the state says that, in fact, 2 out of 13 witnesses have been examined. Stop. The next schedule.
Subject to correction, madam, the order also reflects that 2 witnesses has already been examined. The order,
About the next schedule
August, 3rd of August to 6th of August.
for examination of witnesses has been fixed during 6 from August
13th May
3 to August 6, 2024.
My lord, 2 witnesses are examined.
Stop. He says that within 6 months, the trial may be completed.
The evidence, madam, not the trial, madam, but the evidence.
Evidence. The recording of evidence may be completed. Paragraph. We have considered the facts and circumstances of the case. Stop. There appears to be prima facie incriminating evidence against the petitioner. Stop. Hence, we are not inclined to grant bail.
Kindly do not record this because I have not submitted anything on merit.
If your lordships record this, there is primarily included materials.
Whatever you say, we'll record it. We'll go through the CD and record it. So prima facie means prima facie. It doesn't have any bearing on the trial.
No, my lord, next time it will be construed as a rejection on merit.
Very well. Prima facie টা কেটে দাও, ওটা কেটে দিয়ে বলো, considering the material on record and the restriction in section 37 of the NDPS Act, we are not inclined to enlarge the petitioner on bail immediately. Paragraph. However, we cannot lose sight of the importance of the right to liberty, personal liberty. Stop. Since the petitioner has been in custody for more than a year and 10 months, we direct the learned trial court to expedite the trial to the fullest and complete the same at the earliest, but definitely within 6 months from the next date fixed for recording of evidence. Paragraph, we make it clear that if within the time period indicated above, the trial is not concluded, আমরা তো ট্রায়ালটা বলছি, is not concluded, the petitioner will be at liberty to renew his prayer for bail.
Look, the completion of evidence, my lord, the 313 stage, I cannot even take out an application for bail. CSP is saying the conclusion of evidence. After that 313 stage, I cannot take out an application for bail also at that.
No, we said trial will be concluded.
I'm great.
My submission was the evidence will be concluded.
Your submission we have recorded. Our direction is different.
38.
Yes, my lord, this is a renewal application, and very unfortunate that after passing the order by your lordships, kindly just page 9, earlier rejection, there is a direction of the trial court that the matter should be concluded within a year. Though within a year is not completed right now, but the progress of trial out of 13, after rejection of the first application, out of 13, only 3 witnesses have been examined. And the man in custody about 2 years, 6 months. And very unfortunate, kindly sees the charge sheet submitted in the year 2022. And subsequently the supplementary.
Sir, sorry. 19th December 2023.
Yes.
The coordinate bench granted one year's time.
Yes.
From the next date fixed.
Yes. Right, my lord. But from the rejection of that application, only out of 13 witnesses, only 3 witnesses have been examined.
Come back after 1 year. We'll see.
And the please and the remaining portion is this. Kindly sees because the trial is delayed from very beginning. Charge sheet submitted in the year 2022.
You never know. They can expedite within the remaining period also. How do we know?
But can it be possible? 13.
Everything is possible.
13.
As Napoleon used to say, impossible is a word found in the dictionary of the. Yes, what is it?
My lord, on 4th of April 2024, co-accused person who has been arrested, who is then on the same footing. That my learned friend is referring the order dated December 2023.
He is saying 1 year's time was granted in December 23. After that,
4th of April, my lord. That order has not been annexed. My lord, I don't have the, my lord, kindly see this
4th
order.
of April. From 4th of April, 1 year time has been granted?
Yes.
Where is that order?
My lord, that
What the same accused?
No.
Co-accused is the same person.
Same
co-accused.
Similarly placed.
Trial is the same?
Yes.
Similarly placed.
Where is it?
But excuse me for, I don't have the printout.
The only problem is that now that you have handed this up, this has to be marked as an exhibit and it can't be returned to you. (11 witnesses in this case?
13 witnesses.
Total 13 witnesses, 3 witnesses are already been examined.
So how do we know this is the same case? This is.
My lord, kindly see the name, case number is there, my lord, at the top.
Matia police case.
Matia PS case number 346.
346, 2020, dated 6/9/2022.
But this order is not in lordship's file.
How can it be?
It should be.
Respect of
Now the
another accused.
No. PS case, according to the PS case, they are giving this from the department. That is not possible for them.
Yes, it doesn't say 1 year. It says at an early date.
Yes, early date. 4-4, no? Yes. Ajoy Mukher petition.
Sir, come back after 1 year.
My lord, may I request one thing?
Yes, that
May I
is-
request
yes.
one thing?
That
Can
should be, my lord.
it be
Because now
possible
the
to call for a
department is-
report from the trial court regarding the progress of investigation?
Why?
Progress of trial.
1 year time has been granted. Why?
Sir, today or
Issue.
also the date fixed for trial. 25th of June. No.
But out of 13 witnesses,
Just a minute, 4/4/2020.
out of 13 witnesses, can it be
There
possible?
is a direction to complete within 1 year. Trial court is directed to expedite the trial in view of assurance given by the prosecutor and conclusive at an early date.
Yes, my lord.
There is only 1 year time.
That what
About 1 year.
that is what I am submitting, because my magistrate is referring a earlier order. I am referring the latest order.
But that is
That
1
has
year.
got no time bound in the last order.
Lehu. The petitioner renews his order for bail. Stop. He is one of 2 accused persons.
Three accused persons.
Three
And he is the
accused
driver of the car, offending car.
Stop. এটা কত নম্বর 38 অশোক দেবনাথ. His prayer for bail was earlier rejected when
19/12/2023.
by an
Page
order
9, my
dated,
lord, page
by an
9.
order dated December 19, 2023, passed by a coordinate bench in CRM NDPS 1976 of 2023. Stop. By that order, the coordinate bench had directed the trial court to conduct the trial with utmost expedition and conclude the same at an early date, preferably within 1 year from the next date fixed before it, without granting unnecessary adjournment to either of the parties. Stop. Paragraph. The petitioner says that after passing of the said order, no substantial progress has been made in the trial. Stop. Till date, only 3 out of 13 witnesses have been examined. Stop. It is practically not possible to conclude the trial within the time period indicated in the aforesaid order of the coordinate bench. Stop. He should be enlarged on bail. Paragraph. Learned advocate for the state says that one of the co-accused persons was arrested and he had applied for bail by filing CRM NDPS number 540 of 2024. Stop. That application was rejected by the coordinate bench by an order dated April 4, 2024. Stop. That order records that the prosecution assures the court that remaining witnesses shall be examined within 1 year from the next date fixed for recording evidence, subject to cooperation by the defense and systemic reasons. Stop. The court disposed of the bail application by directing the trial court to expedite the trial in view of the assurance given by the prosecution and conclude the same at an early date. Paragraph. The period of 1 year has not yet elapsed. Period of 1 year from December
2023.
December 19, 2023, has not yet elapsed. Stop. We are therefore not inclined to entertain this application for bail. Stop. Paragraph. The application, etc., stands dismissed. Paragraph. The আর কিছু বলো না, dismiss, at this stage.
39, I beg to appear on behalf of the petitioner, my lord.
Please take back your mobile.
আর মোবাইল ফেরত দিয়ে দিয়েছি তো মোবাইল না এইটা
My lord, allegation is under section 29C, read with 29 along with section 25 1A Arms Act. My lord, the
27 arising out of same case, your lordship was pleased to fix item number 27 on 27th of June, my lord.
27th of June, my lord.
Day after tomorrow.
Grateful, my lord.
Date evidence is today, my lord.
Date of evidence is today.
Day after tomorrow. You give the other number, tar pore parle diye diyo bhai. Yeah. Give the other number.
Item number 40. My lord, item number 40, I'm for the petitioner, my lord. My lord, I'm praying bail on parity, my lord. Page, my lord, 11 and 13, my lord. No narcotics record. No narcotics record from the possession of the petitioner, my lord.
Esho, no contraband item was recovered from the petitioner. Stop. He claims parity by referring to two orders dated 9 and 11.
Yes, my lord.
9 or 11 and 13.
11 and 13, my lord.
Two orders dated April 24, 2024, passed in CRM NDPS 708 of 2024, and dated April 29, 2024, passed in CRM NDPS number 727 of 2024, whereby two co-accused persons have been enlarged on bail. Stop. He says that he stands on the same footing as those persons. Paragraph, learned advocate for the state in his usual fairness admits that the petitioner is similarly circumstanced as the two co-accused persons who have been enlarged on bail by this court. Paragraph, hence we are inclined to allow this application for bail. Paragraph accordingly.
Grateful, my lord.
41.
41, my lord, I'm for the petitioner, my lord. My lord, this is a case under section 21C, 27A, 29 of NDPS Act, my lord. May I place the FIR fact from the FIR, my lord, first? My lord, it is alleged that, my lord.
How long you are in the custody?
My lord, 290 days, my lord.
290 days.
Yes, my lord.
290 days, not 1 year.
About 1 year.
What was recovered?
No narcotics recovered from my possession, my lord. The fact is that in fact of this case, my lord, the police, the complainant said they were patrolling, my lord, in a motorbike, my lord. One Toto started speeding, my lord. Police got, it was suspected, my lord, that there is something wrong. The police tried to chase that Toto, my lord. Toto take turn and enter into a village, my lord. Thereafter, my lord, the driver who escaped from the Toto with the sack, my lord. Two persons were also there in that Toto, my lord. They were caught, my lord. From their possession, my lord, narcotics recovered, my lord. Fentanyl recovered, my lord. At that time, my lord, police started attacking on that persons on that two person, my lord. Some people they come and there was a fight with the local people and police personnel, my lord. Allegation against me that I'm one of the local people, my lord, one of the person. No narcotics recovered from my possession, my lord. It is from that two person and that Toto, my lord.
Correction, prayer for bail of two co-accused has been turned down. Observations made by the court. Now I place the statement of the injured civic volunteer who was beaten up. One in the month of April this year. All stand on the same footing, madam.
No, this is allegation of injury.
Allegation of injury, madam.
No.
After recovery of the fentanyl bottle.
Fentanyl was recovered from him.
Not from him. He's a part of the gang. What had happened, my lord? The e-rickshaw. E-rickshaw was chased. 2-3 fled away from there. It was intercepted. The sack was recovered from the e-rickshaw. Immediately, the persons who were apprehended called some more persons. All of them came and had beaten up the police person. He is a part of that. So whether he is connected to only the beating up.
Your investigation is not complete.
A charge sheet has been submitted.
Charges have been framed. Next date is on 22nd July, 23rd July for evidence.
Yes.
Co-accused on the same footing.
Madam.
But you kindly see.
Yes.
No narcotics was recovered from them as well.
Yes.
24th April and one in the month of November. And even in the FIR, all of them were.
Why you attack police after that?
My lord.
Why you attack?
Even that, my lord, there's no independent witness in this regard, my lord. Totally allegation from the side of the police personnel, my lord. There has to be some independent witness, my lord.
The injury?
Page 14. But if 7 I have taken out for your lordship's consideration, that's the statement.
Page 14.
Page 14, injury on the head with 3 stitches. My lord,
पुलिस के द्वारा
second part, my lord.
হ্যাঁ ওইটাই বলছি So pagination, correction, then again put 17, 15, physical assault or something like that. Or please show us.
Injury on the head with 3 stitches. I'll take it out.
Now, how long he is in custody?
290 days, my lord.
Then it should be liberal, no?
The petitioner says that there was no recovery of narcotic substance from him. Stop. At the highest, he was involved in a scuffle with the police personnel. Stop. He is in custody for
290 days, my lord.
290 days. Stop. He prays for bail. Stop. Paragraph. We have seen the material in the case diary. Stop. It appears that a group of persons, including the petitioner, beat up police personnel who had tried to seize contraband items from the accused persons. Stop. This is the first application he's making.
Yes, my lord. This is my first application. My lord.
Stop. Prayer for bail made by co-accused persons standing on the same footing have been rejected by a coordinate bench. Stop. He would definitely be involved in the narcotics trade, otherwise he wouldn't have attacked the police people. Paragraph. On an overall consideration of the facts and circumstances of the case. And now, we have also seen the injury report. Stop. Assaulting police personnel itself is a serious offense. Stop. One of the police personnel received head injury. Stop. Paragraph on an overall assessment of the facts and circumstances of the case and the possible extent of complicity of the petitioner in the alleged crime, we are not inclined to entertain the petitioner's prayer for bail, at this stage. Paragraph dismissed.
42.
The petitioner bail prayer was earlier rejected by this honorable court as well as by the honorable apex court. Even the last rejection before this honorable court on November 2023 and before the honorable apex court February 2024. My lord, thereafter one schedule expired. Out of 11 witnesses till date, no one examined, my lord. And I am in custody for more than 1 year, 9 months, 27 days.
Charge sheet has been submitted when?
My lord, charge sheets have submitted on
Charge was framed on September
2023.
And my lord, the next date is fixed on 10th of July for evidence of PW1.
How many witnesses?
My lord, evidence of PW1 on 10th.
How many witnesses?
The 10 months have elapsed from framing of charge.
Yes, sir.
Then,
But considering the same, the apex court has rejected his bail free perfectly.
And my lord, thereafter one schedule expired.
Order at
I have annexed that order, my lord.
page
10 of the petition. 5,000 bottles of pencil. Completely. And there are independent Caesar witnesses who have supported this purpose.
Expedite.
On last occasion, admittedly, on last 3 dates, the witness report not of
Issue.
was a sensory order to that.
your witness we shall pass necessary order. Why?
So that the learned judge.
The
takes
petitioner's
case
prayer
and-
for
No.
bail was earlier rejected
What's the step, my lord?
by a coordinate bench by an order dated November 20, 2023, passed in CRM NDPS 1761 of 2023. Stop. 2011. The petitioner had carried such order to the Honorable Supreme Court by way of a special leave petition, which was dismissed by the Honorable Apex Court by an order dated February 23, 2024, noting that huge quantity of cough syrup had been seized and that charges have already been framed in the trial court. Paragraph. The petitioner renews his prayer for bail. Stop. He says that he is in custody for 1 year, 9 months and 27 days. Stop. Witness action has not even begun. Stop. There is no possibility of an early conclusion of trial. Stop. He should be enlarged on bail. Paragraph. Learned advocate for the state says that the Honorable Supreme Court very recently rejected the prayer for bail, noticing that charge has been framed. Stop. The schedule for examination of witness has been fixed
9th, 10th, and 11th of July.
from July 9 to 11, 2024. Stop. All endeavors will be made to bring the trial to an early conclusion. Paragraph. Since 5,000 bottles of Fencidril is involved, comma, and there is prima facie incriminating evidence against the petitioner, comma, we are not inclined to allow the petitioner's prayer for bail, keeping in mind the restrictions in Section 37 of the NDPS Act. Stop. Paragraph. However, since the petitioner has been in custody for quite some time, comma, we request the learned trial court to expedite the trial, comma, if necessary, by fixing frequent schedules for examination of witness, and bring the trial to an early conclusion. Early conclusion, comma, preferably within a year from the next date fixed for recording of evidence. Paragraph. If the trial is not concluded within the time period indicated above, comma, the petitioner will be at liberty to renew his prayer for bail.
HON'BLE. 43.
My lord, I am not pressing this application since my application was rejected on 7th February. But by this time, one of the accused approached this court.
Mr. Roy, you're not pressing it. Full stop. Hey, likhe dao.
But my lord,
This month only your lordship has rejected the co-accused prayer for
my
bail.
lord,
Sure.
whether, my lord, after not pressing, may I, my lord, beseech your lordship for a direction
No.
for
Not press on them.
44.
I'm for the petitioner. My lord, on last occasion, petitioner's bail prayer was rejected on August 2023. My lord, thereafter, I am in custody for 2 years, 1 month.
2 year.
2 years, 1 month. My lord, only 25 bottles of Fencidril was recovered. Till date, out of 8 witnesses, none has been examined. And
25 bottles.
25 bottles of Fencidril. My lord, one schedule expired. 8 witnesses are there. No one was examined.
My lord, charge was framed when?
Charge was framed on 5th of December 2023. His prayer for bail was rejected on 30th of August 2023. Thereafter, supplementary charge sheet after the collection of the chemical report was filed on 29th of August 2023. Charges have been framed on 5th of December 2023. First schedule was fixed. First schedule failed because of the ensuing elections. Since the accused person in custody was not produced due to the election duties. So, my lord, the second schedule has been fixed on 22nd of July. And my lord, only 9 witnesses are to be examined.
How many? 9.
My lord, no one examined till then,
Commercial
only 25 bottles of NCDL, only charged frame.
25.
Only 25. More than
Details.
2, more
But
than
it's
2 years,
commercial
1 month in custody.
Commercial quantity. Above 1 liter is
I'm
commercial.
praying for bail on the ground of delay, my lord.
You're in custody for?
2 year, 1 month.
He is in custody since 21st of May 2022. So that is going to be
2 year, 1 month.
Charge sheet was submitted when?
My lord, charge sheet was submitted on 11th of November 2022. My lord, there were co-accused persons who were enlarged on anticipatory bail. Thereafter, they appeared before the court and were granted regular bail. If I may just show few orders to your lordship, my lord,
No,
they are,
look here. November 22 charge sheet submitted.
my lord,
And charge was framed on
5th of December 23.
23. There was এক বছর বাদে।
Co-accused persons were not appearing. There were co-accused persons who had filed for anticipatory bail before this honorable court.
দিয়ে ছেড়ে দাও, উপায় নেই।
Thereafter, they had
পারবে না,
appeared.
না হলে ছেড়েই দাও আর কি। You see, 8 months is over, right?
8 months.
Sometime more. We'll just make a time-bound program. Otherwise, you come, we'll grant you bail. The petitioner renews his prayer for bail, which was rejected.
August 2023, my lord.
30th of August 2023.
August 2023. My lord,
30th of August.
30th of August.
Sinarul Islam, yes. Which
my lord, page 10 of my application.
Page 10, my lord.
page 10, Sinarul Sheikh.
Co-accused were absconding. That's
They were granted anticipated bail.
Which was
No recovery was.
But my lord, on last schedule, no.
earlier by a coordinate bench by an order dated August 30, 2023, passed in CRM bracket NDPS 1281 of 2023. Paragraph. The petitioner says that he is in custody for more than 2 years.
1 month.
More than 2 years, 1 month. Stop. Not a single witness out of
8 witnesses.
8 witnesses has been examined till date. Stop. He prays for bail on the ground of delay in progress of the trial. Paragraph. The state opposes the prayer. Stop. It says that charge was framed in
December
2023. Stop. The first schedule fixed for examination of witnesses failed because the accused could not be produced due to general elections. Stop. The next schedule has been fixed
2nd of July.
on July 22, 2024.
Only 1 day.
No, my lord.
23rd, 24th.
From July
22nd.
22 to July 24, 2024. Stop. All endeavors will be made to conclude the trial at an early date. Paragraph. We do notice that the petitioner has been in custody for quite some time. Stop. However,
Accused were absconding.
we also note that there was some delay in the trial because of the fact that the co-accused persons were absconding. Stop. Commercial quantity of contraband was recovered from the possession of the petitioner. Stop. We are not inclined to allow the petitioner, inclined to grant bail to the petitioner, at this stage. Stop. Paragraph. However, since personal liberty is extremely important, we direct the learned trial court to expedite the trial to the fullest and bring the same to its conclusion at an early date and definitely and positively within 8 months from the next date fixed for recording of evidence, paragraph, recording of evidence, comma, subject to the petitioner fully cooperating with the learned court, petitioner Borna, subject to both the parties fully cooperating with the learned court. Paragraph, we clarify that in the event the trial is not concluded within the time period indicated above, comma, the petitioner will be at liberty to renew his prayer for bail.
My lord, may I only submit one thing? My lord, the other co-accused were granted anticipatory bail in July 2022, my lord. And
Yes.
thereafter they are regularly. I have annexed
no.
all the order.
May,
I have annexed all the order sheets. In July 2022, they were granted anticipatory.
yes, since
That's
May.
all right, may not
Now
be.
we are in 2024, 2 years.
No, we asked them why there was so much delay after filing of charge sheet to making.
But there is no other
According
co-accused
to
persons are not absconding, my lord. I had so far the order sheets are
Oh, they
It
have
it is a bit. I have annexed the entire order.
they
sheet.
were absent also on few dates.
But absent and absconding are two different aspects, my subject to lordship kind sanction. But in 2022, they have been granted anticipatory bail.
Yes, so started
Were
in
not
May.
were not present absconding টা কেটে দাও
absentee.
তো কি বললাম ওখানে বলেছিলাম, but absented themselves from the trial court.
Absent.
Obliged.
45.
45, I am for the petitioner. My lord, in this matter, I am in custody for 1 year, 17 days only.
1 year, 17 days.
17 days. From my possession, 32 kg of gaja was recovered.
3 petitioners.
My lord, 3 petitioners before your lordship.
Three
And
only 3 accused persons.
no, my lord, there are other accused persons also, but from these 3 petitioners, the recovery was made.
First application.
No, my lord, second application. Earlier rejected on April 2024. Page 9 of my application.
This year.
This year, my lord.
What is the change of circumstances?
No, they have taken a point in the petition that there was no videography of the entire process of the search and seizure. Now, my lord, the concept of videography of search and seizure only came into existence after my lord Justice Bakchi's direction in Kalu Sheikh versus State of West Bengal in CRM number 490 of 92 of 2022. Because my lord Justice Bakchi found in series of cases that the police atrocities in framing of false cases. That's why this videography of search and seizure. Now, my lord, page 21. My lord, of my case, right, the entire search and seizure has been videographed. That has been done. This is the only point they have taken. And it has been covered up by our investigating agents.
What is the stage?
My lord, still 2 persons are absconding. The stage is next date is for the production and copy service.
1 year has gone by.
True. But my lord, if the other co-accused persons are absconding,
Let us say they are absconding for the next 3 years.
My lord, then they have to prefer a 299 application for splitting off of trial. They have not done it.
They will have to file it, otherwise the court will not do it.
My lord, the suo moto, the
Court doesn't have the power.
My lord, court have the power, but 299, if your lordship kindly see.
We kindly refer 298, please read.
Yes.
299 of what?
CRP.
Duty of the prosecution.
Please. Do you have any copy of CRPC?
No, I have a CRPC.
299.
Let us come to 299. That's right.
299 of CRPC.
Duty of the prosecution to split up the trial, man.
I'm not denying that. And moreover, my lord, the supplementary charge sheet is yet to be filed because the chemical examination report is still pending. It's awaiting.
Yes, please read. Whether it is a bounden duty upon the accused or prosecution or court. You tell me.
Record of evidence in terms of accused. If it is proved that an accused person is absconded and there is no.
This is the court. The
Issue, issue.
court. That is the duty of the court. That's the duty of the not him. Not the accused. Okay. Okay. Deep level.
Where is the rejection?
Page 9, annexure P1.
This is Jakir Mullah.
There are 3 petitions. Now, my lord will find in this present application, there are 3 petitioners. Last time one has referred.
Is the petition number 2?
Yeah, so this is the renewal only insofar as petitioner number 2 is concerned. Dekho, this the petitioner number 2 renews his prayer for bail, which was rejected earlier by an order dated April 18, 2024, passed in CRM NDPS 673 of 2024. Stop. Insofar as the petitioner numbers 1 and 3 are concerned, this is the first application for bail. Paragraph, the petitioners are 3 out of several accused persons. Stop. Contraband, commercial quantity of ganja was seized from the joint possession of the accused persons. Stop. Paragraph, the petitioners say that they are in custody for more than a year. Stop. The process of seizure was not videographed. Stop. That is an incurable infirmity in the prosecution case. Stop. They should be therefore, enlarged on bail. Paragraph, a learned advocate for the state produces the case diary and shows us that the entire process of seizure was videographed. Stop. Therefore, paragraph, therefore, there is not much substance in the point raised by the petitioner. Stop. In view of commercial quantity of contraband item being involved, keeping in mind the restrictions under section 37 of the NDPS Act, we are not inclined to entertain the prayer for bail. Paragraph, however, since the petitioners are in incarceration for more than a year, the learned trial court is directed to expedite the trial, if necessary, by splitting up the same under
section 299 of CRPC.
In accordance with law. In accordance with law, so that the trial may come to an early conclusion insofar as these petitioners are concerned.
Deeply. Deeply.
Okay.
46.
Lord, as for the petitioner.
Sorry?
I am for the petitioner. Well, in this matter, I am praying for bail on the ground of parity. From the joint possession of 2 accused persons, 10-liter codeine mixture recovered, and one of them has been granted.
Where is that order?
Well, at page 10 of my application.
Only, my lord, there are criminal antecedent against this petitioner.
Whatever
Otherwise, standing on similar footing.
He moved at least 5 bail applications. This is the last. There's a chance to get bail for his client.
Delay in trial, what can be done?
Out of 14, 4 witness has already been examined.
Now you can take all the time you want to. Now that we are granting bail, you can take 5, 6, 7 years, no problem. The petitioner prays for bail on the ground of parity. Stop. He says that commercial quantity of contraband item was allegedly seized from the joint possession of the petitioner and a co-accused person. Stop. That other person has been enlarged on bail by a coordinate bench on the ground of delay in trial, by an order dated May 6, 2024, passed in CRM NDPS 768 of 2024. Stop. He says that he stands on the same footing. Paragraph, learned advocate for the state in her usual fairness admits that the petitioner is similarly circumstanced as the co-accused person who has been enlarged on bail. Stop. Paragraph, therefore, we are inclined to allow this application. Paragraph accordingly. ওইগুলো জেনে নাও কিসব জানতে হবে।
47
একটা তো পেয়েছি।
This relates to narcotic. And he is in custody for more than 2 years and 4 months. No matter there is a joint possession of 130 bottles of fentanyl from the 5 accused persons.
Any earlier rejection?
No, my lord. But the application of the co-accused has been rejected by this honorable court. That is on 7th of March 2024. So I must be candidate to lordship. But so far the point is concerned that he is in custody for more than 2 years. But may I just point out
what is the
very recent judgment of the Honorable Supreme Court? Very recent judgment.
বাবা কতবার দেখবো সে একই কথা। Sir, we have seen.
Just on the same point that he was in custody for 2 years and some months.
It is no, sir, it is no declaration of law. We have seen these orders.
Now,
what is the stage of trial?
Just a minute, my lord. Just a minute. 3 witnesses have been examined in the meantime, out of 7 witnesses. Now, my lord, the last witnesses were examined on 3rd of August 2023. Since then, no examination of witnesses have taken place. No witnesses. Last witness was examined on 3rd of August 23. But the problem is here, my lord, which I should point out to your lordship. The order of this coordinated bench. People also can have a look at that. That was passed on 7th of March 2024. This court directed with the assurance of the London lawyer for the state that the trial would be concluded by 6 months. But my point is, since 3rd of August 23, no witnesses have been examined by the prosecution. But not only that, on the point, there is not yet any chemical examination report for the last 2 years and 4 months, except the fact that there is not even any videograph. Because last time can have a look at the last judgment of the Supreme Court, that videograph is a must. Even in presence of a magistrate, people also can have a look at that judgment also. Paragraph 16 for a moment, if you also can see. The total search and seizure is illegal. If there is a result of chemical examination, what trial is going on there? It is a fast trial.
Handed over the chemical report examination.
Very well. Let them show the inventory. Let them show the inventory first. What is the inventory, my lord? They're totally violating the provisions of section 52A2. Then it is a, my lord, illegal trial which vitiates everything. Then what is the use of, my lord, dragging of the further trial? And the last witness was examined on 3rd of August 2020.
Why? Well, let me come to after one. Well, kindly see the last order what my learned friend has placed of 7/3/2024. Kindly see the rejection order, my. Now come to the last order of the petition where he has annexed it. My lord, kindly see order number 32 and 33, my lord. Kindly see this. My lord, the witnesses were engaged in the elections duty. That is the reason they could not appear before the.
Not my fault.
My lord, he has annexed in his own petition, my lord.
What I can do?
He has annexed in his own petition, my lord. My learned friend is telling the last rejection from this honorable court, my lord.
Reason for delay is
7 witnesses are there.
reasonable or not. We have to consider. We have to consider reasonableness.
I am putting the question to myself.
Yes.
I am in custody for more than 2 years.
Okay, we shall consider. We shall consider.
Sir, where does Motilal say that videography is must? Which paragraph?
Paragraph 16, my lord. Paragraph.
Look at it. Look at paragraph 16. Paragraph 16 only quotes from Mohanlal's case.
Yes. Paragraph 16, madam, then madam, come to a second. Of section 3 of section 53A requires that the magistrate shall, as soon as may, they allow the application. This implies that no sooner the feature is affected, the contravent forwarded to the officer in charge of the police station or the officer in court. The officer concerned is in law duty bound. We approach the magistrate for the purpose of mentioned above, including grant of permission to draw samples in his presence, which samples will then be
enlisted. The correctness of the list of samples so drawn certified by the magistrate. In other words, the process of drawing samples has to be in the presence and under the supervision of the magistrate. Let them show the inventory.
Where is the videography, sir?
Just tomorrow, বইটা দাও.
Sir, please come back tomorrow. Videography is not there. Come back tomorrow. We have other cases to attend to. Please come back better prepared. We'll take this up tomorrow. Not today. Videography was directed in what, Kalu Sheikh or some case by Justice Bagchi's division bench. Consider it. Consider it. Bring that decision, we'll see.
Yes, madam. And then, madam, what I was trying to submit bureau lordship.
Submit tomorrow, come back, submit together.
Of course, madam.
Yes.
I am get to.
Thank you.
48. I will state, my lord. I will state, my lord. My lord needs some, my lord, one.
Nay, petitioner.
Keep it on Wednesday, my lord. We need to go through the, my lord, case that is voluminous. Next Wednesday, my lord, I'll keep it on 3rd of July, my lord, because it's 3 volume CD, my lord.
The petitioner is not represented. Stop on the request of learned advocate for the state, let this matter be listed again on July 3.
49.
Lord, 49, my lord, I am appealing for the petition. My lord, petitioner is in custody for more than 2 years, 10 months. My lord, after my rejection by this honorable court, one co-accused persons have been granted bail by your lordships on the ground of delay in trial. I have annexed the order.
Rejection is when?
My lord, in February 2024, thereafter, my lord, page 12, one co-accused persons have been granted bail by your lordship. In June 2024, on the ground of delay in trial, my lord, it's a joint position. My lord, I am standing on the same footing.
Same footing then. Issue. Where is our order?
My lord, page 12, my lord. 12 June 2024.
Although the petitioner's prayer for bail was refused earlier on more than one occasion,
twice.
We've seen that. On more than one occasion, he renews such prayer on the ground of parity. He refers to an order dated June 12, 2024, passed by this bench.
Your lordship.
Passed by this bench in CRM NDPS 844 of 2024, whereby a co-accused person was enlarged on bail on the ground of delay in trial. The petitioner says that he stands on the same footing. He is in custody for 2 years and 10 months.
2 years, 10 months, 2 days.
2 years and 10 months. Paragraph. Learned advocate for the state fairly admits that the petitioner is similarly circumstanced as the other accused person who was granted bail on June 12, 2024. Hence, we are inclined to allow this application, paragraph accordingly.
Grateful.
Item number 50.
50, I'm praying for it not to the lordship. 50, I'm praying for it not to the learned senior.
Not today.
Item number 51.
To the petitioner, my lord. Renewal of my prayer, lordship. Allegation under section 21C 29 of the NDPS Act, lordship.
When was it rejected?
Rejected lastly on
18th of April, my lord, it was not pressed.
lastly not pressed, rejected on 17 January 24.
January, my lord.
Lordship, I am in custody for 2 years, 6 months, lordship. 2 years, 7 months, lordship. Lordship, charge has been framed, lordship. Trial has not yet been started, lordship. I am in custody for 2 years.
And your
8,
co-accused
7.
responded
My lord,
before framing of charge.
before framing of charge, which is why
That
there
is
was a-
not clean
Lordship,
state.
what is my fault, lordship? I am in custody for almost 3 years,
How can
lordship.
it be done?
Lordship, what will I do, lordship? I am in custody.
Remain in the custody. You can do
For other,
yes, because you are the co-accused.
I am
If
the
co-accused remain absconded, then what can be done?
other lordship, the prosecution side will take steps accordingly, lordship.
My lord, 3,100 bottles of incident have been recovered from the petitioner's possession. The next dates of trial are 3rd, 4th, 5th of July, my lord, for evidence. Charge has been framed and
How many witnesses?
8 witnesses.
8 witnesses.
My lord.
When charge was framed?
Charge was framed when?
Charge framed on 26 to 24.
My lord.
Yeah, the charge framed which is how much either. 6 months. Do it. No.
My lord, we
How many days in how much time?
2 years, 7 months.
2 years, 7 months. A long time.
3 years. You have to complete.
Paragraph. The petitioner renews his prayer for bail, which was rejected on two earlier occasions. When?
Yes, lordship. Yes.
3 earlier occasions.
3.
One has not been annexed, my lord.
3 earlier occasions, comma, lastly by an order dated January 17, 2024, passed in CRM NDPS 106 of 2024. Paragraph. The petitioner says that he is in custody for 2 years, 7 months. Stop. Witness action has not yet begun. Stop. It is anybody's guess as to when the trial will conclude. Stop. He prays for bail on the ground of delay in trial. Paragraph. Learned advocate for the state submits that charge was framed in February, 2024. Stop. The schedule for examining witnesses has been fixed
3rd, 4th, and 5th, my lord.
from August,
July.
July 3 to July 5, 2024. Stop. There are 8 witnesses.
8, my lord.
8 witnesses. Stop. There is prima facie incriminating evidence against the petitioner. Paragraph. Having considered the facts and circumstances of the case and the material on record, we are not inclined to enlarge the petitioner on bail, at this stage. Paragraph. Paragraph. However, since the petitioner is in custody for a substantial period of time, keeping in mind the importance of the fundamental right to personal liberty and speedy trial, we direct the learned trial court to conclude the trial at the earliest, and positively within 6 months from the next date fixed for recording of evidence, without granting unnecessary adjournment to either of the parties. Paragraph. We clarify that in the event the trial is not concluded within the aforesaid time period, the petitioner will be at liberty to renew his prayer for bail.
Item number 52.
My lord, I am for the petitioner, my lord.
Yes.
The petitioner is languishing in jail for about 1 year to 2 months, my lord.
2 months. Renewal or?
My lord, it's renewal, my lord. Second
application?
Yes, my lord. My lord, if my lordship comes to page number 8, my lord. This matter was taken up before Honorable Justice Bagchi and Honorable Justice Kant, my lord. It was rejected, my lord.
Yes.
And my lord.
Then what has changed?
My lord, the change is that out of the 9 charge sheeted witness, my lord, they are all police personnel. Only one was examined, my lord. Only one, and that too was when the judgment was passed by Honorable Justice Bagchi.
Sir, when was the
And
charge
after that,
framed?
my lord, the charge was framed on 26th November 2023, my lord, and not a single witness. 26th September, sorry, my lord, 26th September
How many witnesses
2023.
are there?
9 witnesses, and only one has been examined, my lord, and that too. Yes, ma'am.
Ayo. Why Ayo?
No, no, my lord. Constable, my lord. Constable. Biplab Mujumdar.
এক বছর আছে এখন।
My lord, Article 21 is getting infringed, my lord.
Yes. Wait for some time. We are granting a time period. If they can't complete, then come back. Article 21 will bail you out.
My lord, father of the petitioner is dead, already dead, my lord, and he is a sole earner, my lord. Please
Issue.
consider this.
The petitioner renews his prayer for bail, which was rejected earlier by a coordinate bench by an order dated December 18, 2023, passed in CRM NDPS 1769 of 2023. Stop. Paragraph. The petitioner says that he is in custody for about 1 year, 2 months.
2 months, my lord.
Stop. Only 1 out of 9.
9, my lord.
9 witnesses has been examined. Stop. His fundamental right to personal liberty is being abrogated. Stop. He should be immediately enlarged on bail. Paragraph. Learned advocate for the state points out that charge was framed in September 2023. Stop. Thereafter, witness action has begun. Stop. All endeavors will be made to bring the trial to an early conclusion. Stop. There's prima facie incriminating evidence against the petitioner. Paragraph. What was seized?
My lord, 11.75 codeine mix.
Paragraph. In view of a commercial quantity of codeine mixture being involved, we are not inclined to entertain the petitioner's prayer for bail at this stage, keeping in mind the restriction in section 37 of the NDPS Act. Stop. Paragraph. However, since the petitioner is in custody for quite some time, we direct the learned trial court to expedite the trial to the fullest extent and bring the same to its logical conclusion.
My lord, kindly give a time frame, my lord.
Giving conclusion as soon as possible, and preferably within a period of 1 year from the next date fixed for recording of evidence. Paragraph. We clarify that if the trial cannot be concluded within the time period indicated above, the petitioner will be entitled to renew his prayer for bail.
53.
53, my lord, I'm just paying for a day's accommodation, my lord.
Yes, sir.
I'm just praying for a day's accommodation.
Not today.
54.
May it please your lordship, my lord.
State.
My lord, nothing recovered from my possession. My lord, even after I was taken into custody, nothing still recovered, based only on statement of co-accused.
How much?
My lord, from the other persons, 10,000 bottles of fentanyl, not from our possession.
You are in custody how many days?
Oh, custody, 54 days. And nothing seized from our possession, nothing apart from
Charge sheet.
Charge sheet has not been filed.
Investigation is not complete.
Investigation is going on. Decide.
Withdraw.
Withdraw.
With liberty.
Not pressed.
No, not pressed. I come back after charge.
We are saying nothing.
55.
May I please, your lordship? I'm for the petitioner. My lord, this is an NDPS case, my lord. Charge sheet submitted without the chemical report, my lord.
The next date for submission of the report is on 3rd of July.
Supplementary charge
Yes,
sheet.
my lord, the next date is 3rd of July, my lord.
Supplementary charge sheet filed.
We have not received it, my lord. 3rd of July is the date, my lord.
That has already been filed on.
But my lord, we have received just the charge sheet, my lord, without the chemical report. Without that, my lord, it will be difficult for us to move with the matter.
Filed in supplementary charge. That has already been filed.
So they don't have it
Give us a
there.
copy.
See.
No, there is They a can give us a copy.
207, 207.
That from the trial court.
3rd of July is the date, my lord.
For what?
It is for submission of the chemical report, my lord. Submission of the chemical report, 3rd of July. Already submitted, my lord.
Submitted on 21st of June 2024. Supplementary charge sheet had already been filed.
Kindly gives us some time, my lord. If we can obtain that report, then we will.
What is positive? Tested positive. Positive, he says.
Tested positive.
I can very
Oh, if your lordship kindly have a look.
Yes. You have a look, no problem. You show him once the report. Result খারাপ কিন্তু দেখতে চায়।
For my satisfaction.
Paragraph.
Not pressed or.
না।
বলো।
Commercial quantity of codeine.
My lord, codeine mixture, my lord. 28 bottles of
fensidyl syrup you are the sole accused, no?
Sole accused.
Was recovered from the possession of the petitioner, who is the sole accused in this case. Stop. He says he is in custody for 50.
More than 4 months, my lord.
For more than 4 months. Stop. He says that charge sheet has been filed without obtaining the chemical examination report. Stop. Paragraph. Learned advocate for the state tells us that charge sheet, chemical report has been filed in court along with supplementary charge sheet on 21st June, on June 21.
The charge sheet dated 21 June 21, 2024.
And chemical report?
Chemical report dated 13 June 2024.
Na, kede dao, last sentence ta kede dao. He tells us. Chemical report dated June 13, 2024 has been obtained by the prosecution. Stop. The samples have tested positive for presence of codeine. Stop. Charge sheet dated June 21, 2024 has been submitted after obtaining chemical report.
Forwarded on 23rd of June.
Very well. Dated is 21. Stop. Paragraph. In view of the aforesaid, and since commercial quantity of contraband item is involved, we are not inclined to entertain the petitioner's prayer for bail at this stage, keeping in mind the restriction in section 37 of the NDPS Act. Paragraph dismissed.
One humble prayer if the trial could be expedited.
4 months, no. Come back later.
56. Now I am for the petitioner, my lord. In this case, the petitioner is in custody for 1 year, 10 months. Charge not yet been framed, as because the PP has not yet been engaged. Last occasion, prosecution took time. On the
second application, the last
yes, I have an and thereafter
It was rejected, but when charge was
two accused was there, they were at the total, my lord. One of the accused fled away from the spot. Later on, proclamation was issued against him. He approached before the High Court. He procured anticipatory bail, my lord.
Your lordship, can you see? Prosecution took time. Even PP has not been engaged. Charge date is fixed. My lord,
So date is the 18th April is just about 2 months ago.
Yes, my lord. Your lordship kindly consider my custody. I am in custody for 1 year, 10 months.
Yes, it was 1 year, 8 months when this was rejected. Now 1 year, 10 months. How many witnesses?
7 witnesses. Your lordship, may I submit one thing, my lord? On the identical case, my lord, coordinate bail granted bail. Your lordship kindly see the order. Kindly see.
Mushkil.
1 year, 8 months. In case of 1 year, 8 months, and on an identical case, bail has been granted.
603 grams of heroin, my lord.
Yes, commercial quantity.
No, in that case, forensic analysis of mobile phone of the co-accused.
Yes, further investigation was going on.
In this case also, the charge sheet was submitted. Thereafter, further investigation was done.
It is not going on now, sir. Further investigation. Now charge can be considered and framed. We'll give that direction.
Your Lordship,
Yes.
my instruction is this. Public prosecutor has not yet been engaged in this case.
We will direct all those things. What is your instruction on that count?
Then your Lordship kindly call for the report.
Yes, we'll call for a report. Yes, Esho. The petitioner says that he is in custody for 1 year, 10 months. Stop. Charge has not yet been framed. Stop. Public prosecutor has not been appointed to conduct the case. Stop. It is anybody's guess when the trial will commence and conclude. He prays for bail on the ground of delay. Paragraph. Let the state file a report on the next date, explaining the delay in progress of the trial, and also responding to the grievance that public prosecutor has not been appointed in this case. Paragraph, list this matter once again next Tuesday.
Yes, sir.
From Malda,
No. What Malda? Malda is outside West Bengal.
Over telephone to pabe ho.
Next Thursday then. Thursday week করে দাও. Thursday week. Date দিও.
Thursday week.
57.
My lord, I am for the petition. My lord, I am in custody for 2 years and 8 months. Allegation is of 2.5 liters of codeine mixture. My prayer for bail was rejected on 9th of January 2024. At that time, my lord, it was erroneously submitted that the petitioner was in custody for 395 days. My lord, I am in custody for 2 years and 8 months. Charges were framed in February 2023. Till date, only 2 witnesses had been examined.
Out of
9. My lord, these honorable courts in a revisional jurisdiction directed the learned trial court to conclude the trial, my lord, at an early date and fixing up schedules of 3 witnesses in each schedule. That, my lord, that order was passed in February 2024. After that, 3 schedules passed, not a single witness turned up. Even on the last 3 occasions, no witness turned up. I am in custody for 2 years and 8 months. My lord, this is an infraction, indolent attitude on the part of the prosecution.
Cases of commercial quantity.
Yes.
First. Now, I admit after the revisional application was disposed of with the directions, the schedules which were fixed, there were no witnesses. The trial. And so far as the period between the framing of charge until the disposal of the revisional application is concerned, my lord, I don't have the order sheets annexed with the petition. So, my lord, that part I.
My lord, 2 witnesses examined out of 9.
Examined as per the main charge sheet, we propose to examine 8 witnesses, 2 are complete. Lastly, rejected in January.
Sir, you take your time. We are not standing in you. We take 5 years. We'll grant bail. The petitioner says that he is in custody for 2 years, 8 months. Stop. His earlier prayer was rejected. His earlier prayer for bail was rejected by your Shayan Haldar.
My lord, I am Shayan Haldar and another.
Haldar and Sonu Gupta.
Sonu Gupta.
Oh.
Both are petitioners here too.
And they are residing.
Petitioners korbe.
My lord, in not 24 Parganas.
She said that their earlier prayer for bail was rejected by a coordinate bench by an order dated January 9, 2024. Passed in CRM NDPS 22 of 2024. Stop. Paragraph. An order was passed by a learned judge in revisional jurisdiction directing that the trial be expedited and completed at an early date by fixing schedules for examination of witness, schedules of at least 3 dates. 3 consecutive dates for examination of a witness. Stop. That order was passed on.
My lord, February 22, 2024.
Likicho. Stop. Subsequent to such order, nothing has happened.
No, my lord. 3 schedules, no witness.
Three
present.
schedules were fixed, but no witness was examined. Stop. The petitioner's fundamental right to personal liberty continues to be infringed. Paragraph, learned advocate for the state, in his usual fairness, admits that there has been some delay in the progress of the trial. Stop. He, however, says that how many examined?
Witness. 2 out of 9.
2 out of 9 witnesses have been examined. Stop. Next schedule.
My lord, on 25th July,
25th, 26th, and
29 July.
Next schedule for examination has been fixed on July 25, 26 and 29, 2024. Stop. Paragraph. We see that there is little possibility of an early conclusion of the trial. Stop. The petitioner's right under Article 21 cannot be undermined. Stop. Paragraph. Hence, purely on the ground of delay in trial, we are inclined to enlarge the petitioner on bail.
I am grateful to you.
Paragraph accordingly.
Not to leave Baguyati PS jurisdiction.
My lord.
And to give local address.
My lord.
IC Baguyati police station.
My lord.
Abhijit.
58.
Grateful to you. My lord, I am for the petitioner. My lord, in this case, the quantity involved is 7 kgs of gaja. My lord, the petitioner was granted bail by this honorable court in 2014. My lord, he was regularly attending the learned court below with no failure. My lord, only during COVID period, he failed to appear once or twice. My lord, on 9th of February 2022, he was arrested in a false NDPS case and thus he was not produced in this case. My lord, warrant of arrest was issued. On 18th of May 2024, he was acquitted in the second NDPS case in which he was arrested on 9th of February. And because of his arrest in that case, my lord, he could not appear and warrant was issued. My lord, now he was again arrested in connection with this case on 27th of March 2024. And my lord, I am in custody for about 3.5 months, 3 months, my lord.
My lord, something different, my lord. This person, my lord, after granting bail by this honorable court, my lord, from 29th of November 2021 to my lord, 26th of March 2024, remain as one. That's 3 years, my lord, you are absconding. That is.
Show me the arrest memo when you are arrested.
In connection with the
second case?
Yes. My lord, will kindly comes to page 9.
Page 9.
And, my lord, I'm sorry. My lord, my apology, page 10.
Page 10.
My lord, this is the judgment of acquittal of the petitioner. My lord, wherefrom it will appear that the petitioner was arrested on 9th of February 2022, allegedly with possession of, my lord, commercial quantity of codeine mixture.
Yes.
My lord, this is the judgment wherefrom it appears that since 9th of February 2022, he was in custody.
Yes.
And my lord, thereafter he was acquitted by the judgment dated 18th of May 2024.
Let me take some instant.
My lord, this is on record.
We'll take instruction and come back.
This is on record.
Learned advocate for the state seeks a little time to obtain better instructions. Paragraph as requested when?
Next week, Monday.
Let this matter be listed again on Monday date.
My lord, I'm grateful to you.
59.
My lord, I'm in custody for 132 days. My lord, case has a very weird history. My lord, in 2019, 21st of December, a group of boys were apprehended by the police. My lord, no NCB, it's police. My lord, they say one person could be apprehended and the rest they fled away. Now, my lord, from that particular person, 1 packet of ganja was recovered. That was not weighed. Now, the police says that they searched the locality and from the vicinity, they found some other packets of ganja. Now, all these ganja together, those were found in the vicinity and from this boy, man called Jahangir Mondal, they were weighed and they were found to be 24 kilograms in weight. Now, this Jahangir Mondal, he was taken to custody. Now, he named 6 persons. My lord, this is very important. My lord, will kindly come to page 21 of my petition. My lord, he names 6 persons. My lord, will kindly take this into note. Page 21.
Yes.
I am the sixth person, Shora Mund. Now, my lord. Now, my lord. Shora. Yes, I am Shora. Now, Mondal will kindly come to next page. Page 22. That is the charge sheet. My lord, why the name of 3 persons have been dropped out? Only 3 have been charge sheeted. 22. The next page.
Yes.
My lord, accused person charge sheeted 3. My lord, what prompted them to drop the name of 3 accused persons? No one knows.
Yes.
Whatever, 3 names were taken. Now, my lord, what happened? This Jahangir Mondal's case was segregated under section 299. His trial was held. Now, he has been acquitted. He stood acquitted. Now, my lord, after his acquittal, I was arrested. I am in custody for 136.
He has come after the acquittal of the principal accused who was arrested and subsequently faced a trial. His prayer was after proclamation, attachment, everything, it was filed, absconded for 5 years. He could be arrested now. But the trial date has been fixed, 11th July 2020.
But my lord, only if the co-accused has been acquitted, my lord, section 37, my lord, talks about conviction. If the main accused on whose statement I have been acquitted stands acquitted, my lord, section 37 speaks of conviction only.
But this is a discretionary.
That is 100.
You may again abscond.
I will not.
That is the only ground.
That
is the only.
But that I will not.
That's the only thing traveling us.
That I will not. Malad will put me under any condition.
That's why, Milord, I have not said commercial quantity.
Malad will put me under any condition. 24 kgs of ganja.
What is your submission? So
but that is the only absconsion part. Otherwise,
I'll meet the IU every day, my lord.
Expedite the trial. It could be
I'll meet the IU every day, my lord. If so required, I'll do that.
He was arrested.
Yes, subsequently after the acquittal only.
That is also. But I'll meet
he was watching.
They all say that, sir.
But I'll do that.
Of course, that is your instruction. Issue.
No, your appointment is temporary. Our appointment is also temporary. Your Bhokalatna Gan, my determination Gan.
But 132 days and for without any reason, my lord, nothing was recovered from.
Whether without any reason or not will be decided at the trial.
Kindly consider another one more thing, my lord. The packets were found scattered in the vicinity. It was not even seized from this man, Jahangir.
You have a very good ground.
Petitioner says that
Makes all the
principal accused has been acquitted. Stop. Thereafter, he has been arrested. Stop. There was no recovery of contraband from him. Stop. He is in custody for
132 days.
32 days. Stop. He should be enlarged on bail. Paragraph. Learned advocate for the state says that there were 6 accused persons. Stop. Charge sheet was issued in the name of 3 persons. Stop.
principal accused.
The principal accused, the case of the principal accused was segregated and he was tried. Stop. He was acquitted. Stop. This petitioner was absconding for about 5 years.
More than 5.
Stop.
I was not even aware that this case is pending in school. Actually, I was not
5
aware.
years. Stop.
Allow me to complete.
Warrant of arrest was issued against him. Stop. He was then arrested about 100. Arrested in when was he arrested?
Arrested on 16th of February 2024.
On February 16, 2024. Stop. The date of trial has been fixed on
11th July to 12th July. Well, the schedule has already been fixed.
Dekho.
You adopt all this
Stop.
during evidence. You will be given opportunity to cross-examine.
If enlarged on bail,
Because
the petitioner
That is the punishment.
in all probability will abscond again. Paragraph. We have to agree with learned advocate for the state. Stop. The conduct of the petitioner is far from happy. Stop. He absconded for a long time. Stop. The police has now been able to apprehend him. Stop. There's every chance of the petitioner absconding if we enlarge him on bail. Now, stop. Paragraph. Accordingly, comma, irrespective of whether or not the bar under section 37, bar na restriction, under section 37 of the NDPS Act operates in this case, comma, we are not inclined to allow the petitioner's prayer for bail, comma, at this stage.
Great.
I think that
Item number 60.
For the petition.
Hey, fixed matter আছে I think.
Well, this is my first application. I am in custody for more than 1 year, 3 months. From my position, total 140, from the joint position of the other accused, 144 kg of gaja was recovered.
144?
144 kg gaja. And my lord, till date, only total 24 witnesses are there, and till date, charge has not been framed by them.
Charge not framed. You are in custody for?
1 year, 3 months.
Yes, sir.
Charge sheet was submitted when?
Well, the charge sheet submitted on August 2023.
31st
August
of August
2023.
2023. Charge was framed.
Charge sheet,
has not been framed. Lordship, Today is the date fixed for framing of charge. They have filed the application for bail. The case diary is here. They have right to file application. Yes. Original case diary is here.
What, this is co-accused?
Co-accused. Similar circumstances, the bail turned out.
Same vehicle, co-accused, rejected.
So this petitioner, this is my first application.
Yes, no, we are
Can
not
you
on
say
that.
My lord, I do not.
Similar circumstance, same footing.
My lord.
Issue. The petitioner says that he is in custody for 1 year.
1 year, 3 months.
1 year, 3 months. Stop. Charge is yet to be framed. Paragraph. Learned advocate for the state says that charge is scheduled to be framed on?
From today, Lordship. Today was date.
Oh, says that today is the date fixed for framing of charge. Stop.
Cannot be done.
He also, huh? Stop. He also draws to our attention an order dated March 21, 2024, passed by a coordinate bench in CRM NDPS number 536 of 2024, whereby the prayer for bail of a co-accused person was rejected. Stop. Paragraph. 144 kgs, 144 kgs of ganja is involved. Stop. The same is alleged to have been seized from the joint possession of co-accused persons who were all in the vehicle from which the contraband was seized. Stop. In view of the restriction under section 37 of the NDPS Act, and also in view of the fact that the prayer for bail of a similarly circumstanced co-accused person has been turned down by this court on March 21, 2024, we are not inclined to entertain the petitioner's prayer for bail. Paragraph. However, since the petitioner has been in custody for a considerable period of time, the learned trial court is directed to consider the issue of framing of charge at the earliest, and if charges are framed, to carry the trial to its logical conclusion as expeditiously as possible. Rugby fixed,
330 fixed matters, item number 95 to 99.
কিছু হবে না
95 to 99.
My lord, I am appearing for 95 and 96.
My lord, I am in item 97.
My lord, I am in 99.
I get terribly confused. We'll take it up one by one. 95. Who is the petitioner in 95? Who is the state in 95? You are the state.
Who is for the 98?
98, I am appealing for 48.
The petitioner ke?
Ovik.
92.
Ovik was happy.
Mr. Ovik Bhatto.
Very well, let us do the 95 first.
Well, at 95, the petitioners before your lordship, so far as the petitioner number 1 is concerned, this is the second application. So far as the petitioner number 2 is concerned, this is the first application. Now, my lord, the petitioners before your lordships are in custody for 7 years and 7 months.
Right.
My lord, the similarly circumscribed co-accused persons has been granted bail by this honorable court absolutely on the ground of the long detention and failure of the prosecution to conduct.
You're in
trial.
custody for?
7 years, 7 months.
Bojo.
All.
Everyone.
My lord, these are the orders passed by the coordinate benches. My lord, if your lordship be kind enough to look into this, my lord.
What is the case?
My lord, the case is alleged against this to say there was a alleged racket who were trafficking the infants. My lord, this was the case. Newborn babies and the infant, this was the case. Over that, my lord, the charge sheet was submitted. There were altogether 38 to 39 witnesses, out of which the prosecution has examined 27 witnesses. The examination in evidence of PW 28, that is the investigating officer, has commenced in the month of July 2023. That has been continuing since then. During this period, my lord, the accused persons preferred several applications before this honorable court. In one of such application, my lord, I'll hand over the copy of that.
Incriminating evidences against you?
My lord, that subject to correction, my lord, that matter, that incriminating material of the merit has not been taken into consideration while the honorable coordinate bench released them on bail. If your lordship be kind enough, my lord, that is interim bail. My lord, lordship would kindly see the last orders I have handed over. And these are the orders, my lord, earlier orders where the honorable court has categorically passed directions for repeatedly expeditious directions.
Page number?
My lord, I have handed over the copy, my lord.
My lord, I have been my lord, it is annexed in my petition. Your lordship may find
No, my one by one, madam.
More than
If
7.
your lordship be kind enough to see the orders, my lord, passed
Similar. Standing on the same footing. That is only.
just before that, my lord, the CRM 286 2024, my lord.
What is the status, Mr. Nundi, of...
May I just please agree to hard copy?
no, kindly, Mr. Nundi, please tell us. Tell us.
My lord, because this is required for your lordships to peruse once. Because multiple times this matter, these accused persons came before this honorable court. Multiple times the bail prayer was turned down by this honorable court with a specific direction that the trial to be concluded. Now, my lord, kindly look into this report. What my public prosecutor is facing in the court below, what my investigating officer, who is the last witness of this case, what is he facing in the court below. After that, my lord, I will be placing on other things. My lord, will just at a glance look into this report which has been filed by my investigating officer for your lordship's perusal.
28 is the.
My lord,
28 is investigating officer.
20 is the last investigating officer.
So after that, matter shall
So
become.
after that argument, 313 and argument.
In verse.
Very well, Mr. Nundi.
If they want to.
Let us cut it short. Cut it short. You are not disputing they are behind bars for 7 years? Right. Interim bail, like other cases, we'll post the matter after 2 months or whatever it is. Yes.
This interim bail, whatever has been granted by this coordinate bench, but has been granted on the basis of the delay. But my lord, while the interim bail was granted, but this report which I have asked and the report from the public prosecutor which I have sought for, that was not placed by the coordinate bench. This is the reason I am asking your lordships kindly peruse that. After that, your lordship feels like granting them interim bail, I have nothing to say. But look into their conduct.
কি করেছে মারধর করেছে
examination defer
In these applications, the petitioner number 1 has claimed himself as a day laborer, whereas the petitioner number 1 is the owner of a nursing home. The petitioner number 2 has claimed himself as a homemaker, whereas she is running an NGO.
examination sheet.
Now, the amendments which are being made in the petition
are false.
So all these reports are to be handed over to him. They have to submit on your allegations.
Subject to correction, Millet, I don't know what is the report over there.
That's
But
why
nothing is reflected in the order sheets, Millet. At least from the order sheets, Millet, the order sheets it is affected. That Millet, at least on 9 occasions, the special public prosecutor has took time and the case is pending.
serious allegation. You are making abusive languages against the judges, I think, no? Or
Nothing is there. Lordship would kindly see these are the order sheets, Millet. These are the order sheets, Millet. Lordship would kindly see the
persons were granted interim bail.
Does it reflect from the order, any order from
nothing.
the
I have all the orders are there.
This does not reflect from the order of the trial court?
These no application.
Mr. Nandi, please appreciate there's something called principle of natural justice. Yes.
My lord will grant.
How can we act on the basis of a report from your side prepared at your instance without their participation, without giving them an opportunity?
Let them file a
No, will not.
A report,
To my report, my lord.
which is not on affidavit also.
I can put it on affidavit.
yes.
I can put it on affidavit, my lord.
Will not.
Because this is a serious allegation.
Yes, similarly situate people, let them be 7 years, enough is enough.
And not only this, my lord.
Complete, convict them.
Yes. My lord will kindly look into one thing. In the petition itself, whatever they are stating, in the petition itself, they are claiming themselves as a day laborer. They are a owner of a nursing home, my lord. This is the averment in the paragraphs. My lord, the nursing home probably has been seized, my lord, and that averment does not stand on my way.
We are not on that.
How many witnesses have been examined?
That is the last
28.
one going on.
Last
last
one
one
going
going on for last one.
After this argument and judgment,
9 months time, my lord.
we are giving you 2 months' time.
19.
We are giving you 2 months' time till the end of, we are giving you till the end of August. Right? And we are granting interim bail till the middle of September. In the first week of September, the matter will be listed. If you have convicted them in the meantime, end of the matter. If you have acquitted them, end of the matter.
Evidences.
We are not concerned.
This is not the court, my lord, what the evidence, my lord.
We are not concerned. Issue.
Yes, yes.
Please go and argue the matter.
How many accused persons are there?
My lord, in item
one by one, my lord,
in item number 95, my lord, there are 2 petitioners.
Accused persons also too.
No, my lord. Total 19 accused persons.
All these, yes, that's right.
No, my lord.
All these applications are in connection with the same police case.
There are multiple nursing homes which are involved.
Okay, not the same police station case.
Same police station, one single case, my lord.
SIT has taken over, SIT was formed.
Very well. Very well, 99 accused.
19 accused. 19. 19.
Dekho. অন্য কিছু দিয়ে দিয়েছো 7 বছরের
You did not prefer an appeal against that interim.
No, my lord.
You have not preferred.
That's not usually, my lord, Supreme Court doesn't interfere when that's not a final order. It's an interim order, my lord.
That is a problem.
The Supreme Court doesn't interfere, my lord. Even if in
Assumptions and presumptions. There is chance of absconsion. Chance of absconsion.
Any
My lord, the persons who have been granted bail,
The day laborer or something.
my lord, they are regularly appearing.
They go to Kerala.
My lord, they are regularly appearing before the landed court. They are regularly appearing. The persons, my lord, the persons, my lord,
influential persons.
my lord, no, my lord, the persons who has been granted bail.
Where from he is getting these evidences, my lord, influential persons.
My lord, let them show a single document that they have investigated.
We have got sufficient incriminating materials against you.
My lord, kindly appreciate one thing,
You have to go through the
My lord,
evidence that
my lord, can you hear me for a moment, my lord?
Yes.
My lord, the last,
They are hearing you, but they are shouting.
my lord,
I do not know.
my lord, kindly hear me for a moment, my lord, subject to correction, my lordship. My lord, today I am not on merit. I am on merit. Lordship, yes, your lordship.
I am on merit.
Your lordship, absolutely.
Because last witness is being going to be examined, you are shouting for bail.
My lord,
Yes,
last
you have
witness.
ground for 7 years.
Lordship would kindly,
You have to
lordship would kindly
consider the cases.
my lord, kindly
Each case has to be judged by its own merits.
These orders
Okay.
passed by these honorable
My last
courts, where-
rejection
my lord,
within
where
3
at
months.
least 8 to
Okay, you
9
have to satisfy me.
I'm satisfied.
Hey,
Lordship.
please show me the incriminating evidence against the accused.
My lord, kindly see these. My lord, kindly seize these. My lord, kindly seize these order, my lord.
Okay, go.
Kindly seize these orders for once, my lord.
Yes, tell me.
My lord, would kindly see the orders passed by this coordinate bench for how many times there has been directions for completion of this matter, my lord. Lordship, the first order has been passed on 31st of May 2021, where the date time limit was fixed for 6 months. Thereafter, my lord, it continues in month of June 2022, November 2022. Thereafter, my lord, on November 2022, against the schedule was fixed for 3 months. Subsequently, my lord, at that point of time, since the trial was not going on, this honorable court was pleased to direct that the learned judge in charge, who is because the court was vacant, that court will record the evidence, my lord. In spite of that, my lord, the prosecution could not complete. Now, lordship would kindly come to the compilation I have handed over to your lordship from page 15.
Tell me.
My lord, kindly see, in that case, in that occasion, specific direction was given that in how and which manner the trial is to be completed. Specific dates was given that in these 2 dates, the chief is to be recorded.
Whatever it may be, I want to know whether there is any incriminating evidence against you or not.
Incriminating material is available against the persons who are on bail also, my lord.
Whatever it may be, we get.
My lord, we are on parity, my lord.
Yes.
Parity is also a consideration, and my lord, parity is also a relevant consideration for the extending the relief, my lord.
Okay.
The persons who has been released on bail, 2 of them are doctors who have been involved in the trafficking. They have been granted bail. They have not, their bail order has not been challenged before the Supreme Court. The person who has been released on bail by a coordinate bench, the Makbul Vaidyo, is also owner of a nursing home, which order has not been challenged before the Honorable Supreme Court. The other 2 persons, one of them bail order has been rejected by the Supreme Court. In spite of that, the coordinate bench has granted bail on the ground of the delay, my lord. Therefore, my lord, by humble submission before your lordship, my lord, when a person is invoking the Article 21, the merit subject to correction by your lordship should not stand on this way. And in fact, that was the observation made by the coordinate bench in the order passed in CRM TB 2070, my lord.
Whether decision of coordinate bench is binding upon me.
My lord, I am on the issue of the parity.
Please
My lord,
answer me. Please answer me whether the decision of coordinate bench is binding upon
my
me.
lord, in that case, my humble submission will be subject to correction. If your lordship do not take me amiss, my lord, then your lordship, then subject to correction, my lord. I am on the issue of the parity, because parity is a relevant consideration for the purpose of granting bail.
Okay.
Parity, and the parity which has been extended
They are
for
on
years.
the same footing. You are admitting.
Yes. Yes.
They are admitting, and then we have to grant bail.
Okay, sure.
If you admit that they are on the same footing, we have to grant.
The petitioners.
My only submission to that score is that
Mr. Nondi, we'll try to.
bail was granted, my lord. Then I have those reports which I have placed today that was not placed before the court.
We'll record your objection. We'll record your objection. The petitioners are Act number.
Assist the court in right to on that day.
Taking up separately.
Why not?
Separately.
Yes, my lord, separately orders, my lord, kindly, my lord. Because one person has filed 2 applications and their wakalatnam are required to be looked into by this court.
The petitioners are 2 out of 19 accused persons. Stop. The allegations are under various sections of IPC and also under the provisions of the Juvenile Justice Care and Protection Act, 2015, and Section 5 of the Medical Termination of Pregnancy Act. Medical Termination of Pregnancy Act. Stop. Paragraph. The petitioners say that they are in custody for more than 7 years.
7 years, 7 months.
7 years, 7 months. Stop. The trial, the examination of witnesses is yet to be concluded. Stop. They claim, they pray for bail on the ground of delay in conclusion of the trial. Paragraph. Learned additional public prosecutor strongly opposes the prayer for bail. Stop. He says that only one prosecution witness remains to be examined. Stop. The date for such examination.
But no cross has not comments. No cross has comments. Only chief is yet to be completed. The chief is yet to be completed. Order sheet 2nd July. 2nd of July is the next date.
No, July 2, 2024, is the next date for examining for further examination in chief of that witness. Stop. The trial is on the verge of conclusion. Stop. There is more than adequate incriminating evidence against the petitioners. Stop. Their prayer for bail at this stage should be rejected. Paragraph. We find that a coordinate bench has granted bail to other accused persons in this matter purely on the ground of delay in completion of trial.
It's returnable tomorrow. In few days, its returnable date is tomorrow.
It will come before us only.
Yes.
Granted interim bail, bail bolo na. We find that coordinate bench, ki bollam? Interim bail. Stop. The present petitioners are similarly circumstanced. Stop. Hence, we also grant them interim bail till September 15, 2024. Stop. We do this with the expectation that the trial will come to its logical conclusion by the end of August, 2024. Stop. We request the learned trial court to make all efforts to ensure that judgment is delivered by August 31, 2024. Stop. The paragraph, the interim bail, this interim bail is granted subject to the following conditions. Bole ja ja take diye debe sob.
May I just add one thing? The regular court is vacant. Now the judge in charge is taking over. So my lord, give the direction to the judge in charge. His court is as if very heavy. So what he is doing, my lord, he is taking very less time in these matters, and we are not being able to control.
Very well.
Necessary orders.
তার আগে বেলের কন্ডিশনের আগে the last paragraphটার সঙ্গেই একটা বলে দাও. We are told that the regular court is vacant. Stop. The learned judge in charge is hearing the trial. Stop. We request that learned judge to ensure that the instant trial is concluded by the end of August 2024. তারপরে তো this interim bail is granted following condition, যা যা condition হয় দিয়ে দেবে। আর একটা কি ওই
May I just pray for no adjournment by either of the parties?
Without granting any adjournment to either of the parties, তুই আগেরটাই যেখানে বললে, হ্যাঁ?
May I just add one thing to that?
What are the conditions you want? Tell us.
I need two conditions. One, no unnecessary adjournment by either of the parties. Number two, this man, when on interim bail, should meet the investigating officer or the concerned officer of the
Investigating officer, why?
No.
But I'll
IC টা কি?
Inspector in charge, officer in charge. Officer in charge of Baduria police station.
OC, stop. ওইটা add করে দেবে তাহলে the petitioners আছে OC. That is already there in our bail order.
Otherwise, মানে
তারপরে করে দিয়ে লাস্টে এসে বলো let this matter be listed again on September 10. September 10. The order in other matters will be similar?
No, my lord.
No.
Next
আচ্ছা,
matter,
let us take up
can
next
you move
matter.
to the next
একটা একটা করে নাও ভাই, ভুলিয়ে যাবে। হ্যাঁ হ্যাঁ, আলাদা আলাদা করি।
My lord, the second matter.
Made CRM 1544.
My lord, CRM 1544. There are 4 petitioners before your lordship. My lord, so far as the petitioner number 4 is concerned, there is an issue.
Yes.
Probably after filing this CRM 1544, he has filed another application during the pendency of this application.
Through you.
That is, my lord, second
My lord, this is
petitioner
the-
in item 97.
My lord, this is the issue, my lord.
I had perused the wakalatnamas once.
My lord,
ওকালতনামা কোথায়?
the second petitioner in item 97.
Petitioner number 4 and petitioner number 2 over there.
But we received the wakalatnama through the X.
একটা মুহুরি
তপন কুমার বিশ্বাস।
My lord, in any event, my lord, this
সুমন চক্রবর্তী ইভেন্টটা করে ইভেন্চুয়াস হয়ে গেছে।
The wakalatnama that is on record in this matter has been executed by
Well, the petitioner has executed and that has been affirmed by the, that has been identified.
Filed 2. I am asking your lordships to peruse
my
the
lord, these
wakalatnama.
wakalatnamas are being attested by the concerned correctional home superintendents. My lord, they,
My lord, subject to correction, my lord, the all issues cropped up is this.
Then
this
my lord, I will be praying then this person's whatever application is there, that should be withdrawn and file afresh.
yes, my lord.
And should be dismissed with a cost. And it should be dismissed with a cost, my lord.
you are withdrawing.
Withdrawing in the second petitioner in item 97.
My lord, so
So
far
he
as
is withdrawing
item
because he has filed 2 applications. So I
Well,
will be praying for imposing a cost. Because 2 applications, his averment is not clear. He is coming to the court. He should come to the court with a clean hand.
Very well.
In item 97, second petition.
But otherwise it will be the same order?
otherwise it will be the same order.
Issue. It next item. Huh?
96.
These 4 petitioners are some of the 19 accused persons. Stop. All of them are over 7 years. Stop. They say that, আরে ভাই চলে গেল কোথায় অভিজিৎ? সেম হবে তো তারপরে তো সেম হবে। খালি একটু অ্যাডিশন হবে, যেখানে আমি বলে দিচ্ছি অ্যাডিশন যেখানে হবে, হ্যাঁ পুরোটাই এক হবে। শেষে এসে লেখো learned APP had raised an objection as regards the petitioner number 4. Stop. He drew our attention to CRM 1625 of 2024, which is another bail application filed by one Bimal Kumar Odhikari and Topon Kumar Vishwas, who is the present petitioner number 4. Stop. Learned APP says that Topon cannot maintain 2 bail applications through 2 learned advocates, filed through 2 learned advocates. Stop. This is sharp practice and trying to steal a march over the court. Stop. Paragraph. Learned advocate for Topon in CRM
Item
1625 of 2024, with CRM DB bole debe, DB gulo, says that he is withdrawing that application insofar as Topon is concerned. Stop. that application may be withdrawing করে দাও, ওখানে রেখে দাও। Stop. Paragraph learned APP says that costs should be imposed on Topon for filing 2 bail applications through 2 different advocates. Stop. We appreciate the grievance of learned APP. Stop. However, taking a lenient view of the matter, we do not impose any cost.
May I just say one thing?
Yes.
My let in Topon, because he has filed 2 applications, let Topon file a fresh. But the condition will be same. In both applications, there is a confusion who is the original Topon and who has executed the work.
Why, sir? Why?
Let Topon, let him file tomorrow.
There is no confusion regarding.
Creating problem for us.
Because this is
One we are recording as dismissed, the one that you're.
maybe that was not executed by Topon, which my lord is giving. Because the averment is also there, my lord.
Otherwise সব সেম রইল। হ্যাঁ, না উইথড্রন সকলটা দেখছিটাই উইথড্র করবো, এখানে সাবমিশনটা রেকর্ড করা হচ্ছে।
ওটাই আমি বুঝলাম, একটা জিনিস বলবো।
আছে তাদেরকে
My lord, in the first matter also, my lord, the petitioner number 2 is the lady.
কি দেখছো? মিট করবে না।
মেল পিটিশনার বলে দেবেন, ফিমেল পিটিশনার
97 লেখো।
For the petitioner. My lord, I am withdrawing second petitioner. Petitioner number 1.
Learned advocate for the petitioner says that this bail
98.
petition is not pressed insofar as the petitioner number 2 is concerned. Stop. Therefore, this petition is dismissed insofar as the petitioner number 2 is concerned. Paragraph, every petitioner number 1 টা same it will be.
My lord, same, 7 years, 7 months.
95 এর মতন সেম। খালি দেখো একটা পিটিশনের এখানে একজন তো উইথড্র করে নিল। নেক্সট।
I'm grateful.
My lord, in 98, I am only for one petitioner. She's a lady of 65 years.
Only thing 98 is the third application.
True, and we have disclosed that. The last rejection is in August 2023, when the conditions were laid down.
হলোটা কি? মাথা ঘামিয়ে করো। Renews her prayer for bail. Stop. Her prayer was rejected earlier on 2 earlier occasions. Paragraph, the petitioner says that she is in custody for more than 7 years, 7 months. বলে তারপর যা আছে 95 টার মতো same.
Well, only that she's a lady, my lord.
She is a lady, naturally she will not report to the IO. খালি অন্য কন্ডিশন গুলো থাকবে। এটাই মিস্টার সুর অ্যাপিয়ার করছেন। ও আচ্ছা। In all, he is omnipresent. এটা you are Paromita, female. So this will be the same as 98. 99 টা same as 98.
7 years.
No, but no. But renewal.
One time rejection.
Renewal.
খালি one time তুমি দেখো প্রথমটাই খালি একটু চেঞ্জ হবে। The petitioner renews her prayer for bail. Her prayer was rejected earlier. Twice ছিল, ওটা এটাতে once হবে। এটা once হবে। Otherwise সব same.
দিয়েছে কোন দিয়েছে 99 দিয়েছে।
ডিসপোজ অফ হলো না। সব
তো হয়ে গেছে একটা।
দিয়েছি না দিয়েছি 99 দেয়া হয়েছে দিয়ে দেখি
শোনো
আচ্ছা তো 99 তো
May I pray for one? Yes, my lord has directed the IC of our particular petition to appear before the lordship place. But the matter is, my lord, item 117, my lord. Can it be, my lord, can we wait till 4:30 and thereafter mention, my lord, because that personal appearance is there. Please wait.
Please wait till 4:30. Yes.
Item number 61.
My lord, I am for the petitioner. May it please your lordship. My lord, on 19th of December 2023, the prayer for bail of the petitioner was rejected. My lord, nothing was recovered from the possession of the petitioner, but my lord, it was submitted on behalf of the state that there was a financial transaction apparent with the petitioner with the accused persons, and my lord, it was observed by this honorable court, and my lord, it was rejected after because of that. My lord, thereafter the copies have been supplied. My lord, there is no single iota subject to lordship's correction. If your lordship kindly calls for a report to show whether there is any actual transaction of the petitioner with the co-accused persons financially, my lord, to establish, because from the copies so supplied, there is no single iota of transaction appears with the petitioner and the co-accused person. So, my lord, apparently this submission was
Will
not
that
right.
not amount to us evaluating, assessing evidence?
My lord, if the my lord, if it was a incorrect submission and based on that it was rejected only because of that submission, then my lord, after the copy supplied and my lord, the supplementary charge sheets file, your lordship, if your lordship, if my lord is not pleased to call for such report, my detention will not be fruitful.
Not only on that ground, there are CDR collections. Earlier, the bail was rejected on two grounds that the CDR collected during investigation showed telephonic converse. That is, these are the CDR, lordship. Lordship, from the narcotics were seized from a vehicle, lordship. The vehicle was belonged to the petitioner, lordship. Petitioner's father is the owner of that vehicle. And the petitioner's father, in his statement, also stated that the petitioner used to look after that vehicle. From those that
organized.
My lord, co-accused person has been granted bail with whom there are CDS as well. That is at page 9.
For this incident, there are telephonic conversations with this.
Page 9.
How long in custody?
My lord, I am in custody for 11 months.
Stage?
My lord,
The next date is
charge.
July.
My lord, will kindly see page.
Submitted just in May 17th.
My lord, will kindly see page 9 of my application. That is the order of grant of bail to another co-accused person. My lord, I stand on the same footing. If, my lord, this financial transaction goes, I stand on the same footing.
From his vehicle, and there are CDR connections, lordship, telephonic conversation.
From his vehicle, the contraband?
Lordship, kindly see the same.
No. Caesar list mentioned him. Caesar list mentions him.
Kindly see the CDR.
No.
Our guy, Baba বলছে যে ও use করে ছেলে use
But vehicle does not belong to my name.
Your father's name.
Yes, there are 161.
Your father's
161 statements. My lord, any document of the vehicle.
Oh, it is an investigation stage.
No. Supplementary charge sheet submitted. Investigation over.
Whatever it may be.
161
has some relevance in during investigation.
My lord?
There are insurance policy papers, car papers, page 1.
My lord, in that even Jyotirmoy Mitra is not an accused.
CDR আছে ওর সাথে telephonic conversation আছে
My lord, CDRs are there. My lord, CDRs unless proof, my lord, that cannot prove the nexus. This is a standing.
that is a
It's for the trial, sir.
Fixing all these things. 161 has certain relevance right now.
The petitioner renews his prayer for bail, which was rejected earlier by a coordinate bench by an order dated December 19, 2023, passed in CRM NDPS 1996 of 2023. Paragraph, the petitioner says that he has absolutely no truck with the alleged incidents of trafficking in contraband item. Stop. Bail has been granted to a co-accused person by a coordinate bench by an order dated May 9, 2024. Stop. He stands on the same footing as that person. Stop. No money trail has been established between him and the co-accused from whom narcotics was recovered. Stop. He is in custody for 11 months. Stop. Charge is yet to be framed. Paragraph. Learned advocate for the state produces the case diary and draws our attention to the relevant material, including CDR. CDR. Call detailed reports. Stop. It prima facie appears that the petitioner was in contact telephonically with the other accused persons. Stop. It cannot be ruled out that the petitioner is part of a larger network of organized crime. Stop. Paragraph. In view of the prima facie incriminating evidence against the petitioner and considering the possible extent of his complicity in the alleged crime, we are not inclined to entertain the petitioner's prayer for bail, at this stage. Right. Paragraph. However, we request the learned trial court to frame the charge on the scheduled date.
To consider the issue of framing.
To consider the issue of framing. To consider the issue of charges on the scheduled date. Right. And if charges are framed, right, to carry the trial to its logical conclusion as expeditiously as possible.
I'm grateful.
Item number 62.
I'm praying for not today.
Not today.
Item number 63.
No, I am for the petition.
ধরে ফেলবে আর দুটো আছে সারাদিন
My lord, petitioner is in custody.
Yes, sir.
Petitioner is in custody for 2 years, 7 months.
Renewal or first time?
Renewal, but not a single witness has been examined out of.
Just show us the last rejection. How many rejections?
Two times.
2 times.
Charge. When?
Charge framed 21st May 2024.
Charge sheet was submitted?
2022.
From there was no recovery. They got bail. Now they are responding again. Warrant of arrest issue. Again, review pending. And then they are coming.
That
is. Got a stay. So, my lord, they are running on the sheets. It has been specifically stated since there was a stay order because of those warrant charges were pending. That's the
warrant stay. So you may abscond. That is our submission.
No. All along I am in custody.
You may abscond if you.
No. Your lordship put a stringent condition. Stringent condition.
You will not go out of your house. Do you agree?
Then I remain in jail.
If we allow to go out of your house, you may just run away.
No. Your lordship put a stringent condition for a single occasion. If violates for a single occasion, he is bail.
No charge framed.
Only charge framed.
Witness action has begun.
No.
Huh? How many witnesses?
10 witnesses.
Madam, it takes a time frame and then subject to cooperation for both.
You are in custody for
2 years, 7 months. And in an identical case, my lord passed an order.
Each case is on its own facts, sir. There can't be any precedent on
No. But I am submitting before the lordship. 2 years, 7 months, not a single witness has.
No accusation.
315 grams of.
Madam, 2 years, 7 months is a long time.
the case where the other persons are subjected to the delay.
We are not saying it is your fault. Problem with the prosecution here is always very defensive. We are not saying.
High Court, then how will the case proceed in the lower court? That is my question.
Is that his fault?
Not his fault, but
We are only concerned about his fault. Show us maybe the same matter.
how the evidence
Issue.
is together, the matter.
The petitioner is in custody for 2 years and 7 months.
2 years, 7 months.
4 months. 4 months.
The day-to-day trial if they cooperate because the days for evidence are based on the month of August.
Madam, be reasonable. Be reasonable. Be practical. We are aware of the pressure on the learned trial judges also. We cannot put undue pressure on them also.
This was the last judgment merits. There was not time frame was also not there. Might not be kindly based on that order.
We have seen it's right here. Just because no time frame was framed, therefore the court will not proceed. Is that what your argument is?
Because the matter was shaped by the single bench order.
When was that stay vacated?
The last day, just on 14th of May was the date, and then the order.
2 years, 7 months. বললাম তো তাই নাকি? তাহলে stop. Witness action has not yet begun. Stop. Paragraph. Learned advocate for the state says that it is no fault on the part of the state that the trial could not proceed. Stop. A co-accused person filed a criminal revisional application, obtained a stay of the trial. Stop. The stay order stood vacated only very recently on April 24, 2024. Stop. There is substantial incriminating evidence against this petitioner. Stop. The prayer for bail should not be entertained at this stage. Paragraph. There may be very strong evidence against the petitioner, we are not on that. Stop.
Charge sheet was filed on 10/11.
22.
6th of May 2020.
Charge sheet was filed on May 6, 2022. Stop. When was the stay order granted? When? Date? The stay of trial was ordered by the High Court sometime in 2023. Stop. The entire delay cannot be attributed to the stay order. Stop. In any event, no part of the delay can be attributed to the present petitioner. Stop. His fundamental right to personal liberty under Article 21 of the Constitution is of paramount importance and a sacrosanct right as recognized by the Honorable Supreme Court in diverse decisions. Stop. Any restriction in Section 37 of the NDPS Act must stand overridden by the necessity to enforce the fundamental right to personal liberty enshrined in Article 21 of the Constitution. Stop. Paragraph. Solely on we see no possibility of the trial concluding at an early date. Stop. How many witnesses?
10 witnesses.
Stop. There are 10 witnesses to be examined as per the charge sheet. Stop. Purely on the ground of delay, inordinate delay in trial, we enlarge the petitioner on bail accordingly.
Satisfaction to the other.
Not to leave the local jurisdiction. Police station.
The police station is just a minute, my lord. English Bazar police station.
And to report to the OC English Bazar police station.
যেটা বলছি সেটা অ্যাড করে দেবে।
হ্যাঁ, ওই নামটা ইংলিশ বাজার।
The recovery of 315 grams of brown sugar.
Of
315 grams of brown sugar.
brown sugar. যেখানে তুমি Learned advocate for state শুরুই করো, says that 315 grams of brown sugar was recovered from the joint possession from the joint possession of the accused persons, including the petitioner, ওইটা অ্যাড করে দিও, তারপরে যা বলেছেন।
Item number 64.
Lord, for the petition. My lord, my bail prayer was lastly rejected on September 2023.
What is the name of your client?
My lord, a famous person, my
What is your name? Shahrukh Khan.
my lord, since my last rejection, 3 schedule expired. Last witnesses examined in December 2023.
Last rejection?
In September 2023. Thereafter, 3 schedule expired. Only 1 witness examined in part, and that the prosecution deferred the witness. And last examined in December 2023.
You are in custody?
I'm in custody for 1 year, 11 months, 3 days.
Kindly cease for one.
Almost 2 years, my lord.
Huh?
The impugned order. Date of the impugned order.
Impugnment trial court order.
Page number? Page
5th of June 2023. Thereafter, the
5th of June.
kindly see the impugned order. The first page of the petition.
There is no impugned order, sir.
It is the order of the judgment.
What? No, he's praying for bail because the learned trial court has not, or special court has not granted him bail.
Well, let's see.
This is the order. Now, my lord, your lordship will see.
page number. Which page number?
The first page of the proceeding. Your lordship will see. Kindly see the first page of the
5/6/2023.
And
My
now
lord,
see the rejection of High Court.
yes, my lord, that I have stated in my petition that since then he never moved any other application for before the court field.
After the High Court rejection, you have to, my lord, again move the lower court. This is not maintainable. Because, my lord, after the High Court rejection, he will have to, my lord, make fresh prayer application before the court below. And thereafter only, my lord, the present application can be preferred.
Trial court reject করলো, তখন সে হাইকোর্ট রিজেক্ট করলো। এবার আবার যদি অ্যাপ্লাই করতে চাও তাহলে ট্রায়াল কোর্টে ফাইল চেক করবেন।
Technically, you are on technical.
Where is that law that directly they can't approach the High Court? Where is that law? Show us any law. Show us tomorrow.
So the thing is that kindly considers the last High Court election is on 14th of September 2023 at
Yes.
Page 10.
Yes.
So my lord, they will have to prefer the bail application before the learned trial court.
Where is that law? If High Court has rejected in September 23 and subsequently there's a change of circumstance, let us say, for example, where is the law which says they can't approach directly the High Court but necessarily must go to the trial court? To us. Tomorrow? Tomorrow? Day after tomorrow? Learned advocate for the state says that this application is not maintainable. He says that the petitioner's prayer for bail was initially.
What is your contention so far as his?
My lord,
You want to come prepared on this
yes, my
point.
lord, I'll come also prepared.
Was rejected by the special court, by the learned special court, by an order dated June 5, 2023. Stop. From such rejection, the petitioner had come up to the High Court. The High Court also rejected the prayer for bail. Stop. After that, if the petitioner wishes to renew the prayer for bail, he will necessarily have to approach the learned trial court first. Paragraph, we would like learned advocate for the state to show us the law in this regard. Stop as requested by him, let this matter be listed again on pursuit date ta diye dao.
Item number 65.
60 Death certificate of the amputated right middle finger.
Yes, sir.
এরকম হয় নাকি আবার?
That was creating the my lord confusion.
Well, I have seen
Death certificate of a finger.
Now, my lord, now kindly see the death certificate. It says expired. Kindly see. And cause of death. Kindly see the cause of death.
This is confusing.
Yes, my lord. That my lord confused
The
us also.
injury report or something like.
Injury report is there.
So he is alive.
And that's why 307.
So we will post this. He need not come anymore. We'll post this again day after tomorrow.
Not tomorrow, my lord. Yeah.
We don't mind tomorrow.
Tomorrow. Any day.
এসো ওই তোমায় কেন বলছি তুমি এসো pursuant to our order dated June 20, 2024, the investigating officer is present in court today. Stop. His further personal presence is dispensed with. Paragraph. A report has been filed on behalf of the state. Stop. Let the same be on behalf of the state, dated June 24, 2024, signed by the SI of Police, Kandi PS, Murshidabad. Stop. Let the same be kept with the records. Paragraph from the report. It appears that the death certificate pertains to the amputed middle finger, right? One finger, amputed right middle finger of the injured person. Stop. The injured person is alive. Stop. Paragraph. List this matter once again. Today there is no time. Tomorrow. কালকে ডেটটা দিয়ে দাও। হ্যাঁ? না না ওকে আসতে হবে না। হ্যাঁ ডিসপেন্স উইথ।
আগের দিন order সেটাই ছোট।
জিজ্ঞেস করে থাকলে ওখানে স্যার আছে